May I please the Lordships?
Yes.
Lordships, I beg to mention item number 5, Lordships. Lordship, here I am for the respondent number 3, 4, and 5, Lordships. Lordship, here on the last occasion, this honorable court has directed to file the comprehensive affidavit, Lordship. Affidavit in comprehensive affidavit is under preparation, Lordship. So, Lordship, please to grant 2 weeks time, Lordship.
You are for the state.
Lordship, I'm for respondent 3, 4, and 5.
My lord, I'm for respondent number 2, FCI.
Okay. Who is supposed to file affidavit? The state.
Lordship, it's under preparation, Lordship.
Please. Give them time. Learned government advocate submits that affidavit.
Almost ready, Lordship.
In terms of the court's order dated 22/2/2023,
Lordship,
is under preparation,
Lordship,
and that he may be given further 2 weeks' time
Lordship,
to file the same.
Lordship.
Stop. The prayer is not opposed to by the opposite party. Stop. As paid for. 2 weeks' time is granted.
My lord, I'm for respondent number 2. I have
You want your name to be recorded?
Yes, my lord.
Mr. Your name?
Alam Wapang Au.
Alam Wapang Au
Yes, sir.
appears for the respondent.
Number 2,
Number
FCI.
2, FCI. All right.
May I please, your lordships? My lord, I may be allowed to mention item number 13, my lord.
And just a minute, this previous case was item 4, isn't it? I'm sorry, item 5. Okay. Yes,
My lord, item number 13. Here, I have received the affidavit in opposition filed by the state. I may be allowed 3 weeks' time to file affidavit in reply.
okay. On the prayer made by the learned counsel for the petitioners, 3 weeks' time is granted for filing affidavit in reply to the affidavit in opposition filed by the state respondents.
My lord, in the meantime, the interim order passed earlier may be allowed to continue.
List again after 3 weeks. Stop interim order passed earlier to continue in the meantime.
Obliged, my lord.
May I please, my lords? Lordship,
Yes.
item number 12. State is here to file affidavit in opposition, so kindly grant me
Yes.
3 weeks time, lordship.
What is the matter?
Petitioner is challenging the service rules,
Which service rules?
home guards.
Home guards.
Yes.
Yes, you are for the petitioner.
Yes, Lordship.
How much time will you require?
Lordships, 3 weeks, lordship.
3 weeks' time. Run them again, brother. 3 weeks. As paid for by the government advocate, giving for the state respondents. Further 3 weeks' time is granted for filing counter affidavit. List the matter again after 3 weeks.
Obliged, lordship.
May I please, Lordship?
Yes.
Lordship, I'm making a mention on behalf of Zidane Nguli for item number 6, Lordship. Lordship, since he cannot be here today, Lordship, he is a member of this special committee for this medical college, so he went there today. So if Lordship may kindly this matter next week.
Just bring that file. Item 6. I found one affidavit inside which is not connected to this case. This one. This matter has nothing to do with PIL Suomoto 1 of 2022, isn't it? So this can be kept in that different file. So when do you want it?
Next week, Your Lordship.
All right. On the request made by the learned counsel. On a request made on behalf of Mr.
M. Vero.
M. Vero,
Yes, Your Lordship.
learned counsel for the
Petitioner, Your Lordship.
petitioner. Matter stands adjourned for a week.
Oblige, my lord.
May I please, your lordships? I beg to mention item number 22 on behalf of my senior, Inti Longjam. He has some personal difficulties today, so kindly list the matter on the 29th of March.
22. This is for hearing. Are you there in this case?
No.
What has happened to Mr. Inti Longjam?
He has some personal difficulties.
I see. All right. On the request made on behalf of Mr. Inti Longjam, learned counsel for the appellant, and not objected to by the other side,
Lordship.
let the matter be listed for hearing on
29th of March.
29th of March 2023. All right.
Oblige, my lord.
Much better.
Your Lordships, I beg to mention item number 10. Your Lordship, on the consensus of all the parties, I pray this matter come up on 15 April.
You are for the
Appellant.
appellant. Mr. Jamir is there?
Private respondents.
Private respondents. In fact, this matter is wrongly listed. Matter was already admitted.
Yes,
It should have been listed for hearing,
yes, Lord.
isn't it? So when do you want it?
15 of April.
It's okay, 15?
Lordship.
All right, this matter appears to be wrong since the appeal was already admitted on earlier occasion. Full stop. As prayed for by the learned counsel for the appellant and not objected to by the opposite party, list this matter for hearing on 15th April.
Yes.
15 is Saturday.
Saturday, Lord.
It's a Saturday.
Let it be on 17th. Oh, 17th. 19th. That's a division bench day.
I think 19th would be ideal. On 19th of April 2023. Yes.
For motion, item number 1.
Maybe Lordships.
Yes.
Maybe Lordships. Lordships, the applicants here are before this on the
Mr.
court.
Foseko,
Lordship.
one thing, this, in fact, RFA, it's regular first appeal. Normally, it's heard by a single bench. Why is it before a division bench?
Lordship, the appellant, they preferred this RFA before this honorable court, and the matter has been before this the
No, normally it's handled by a single bench, RFA, even RSA also. Why is it before division bench?
Lordship, that I
Writ petitions are before division
Yes.
bench because some statute rules, service rules and all are challenged. That's why division bench. But RFA, is there any such provision that this should go to division bench, this should go up to single bench like that? You're not aware?
not aware of that, Lordship.
Okay. You're for the applicant?
Applicant, Lordship,
Yes. What is this IA about?
for temporary injunction on the respondent and the appellant in the RFA. The appellant respondent, he is demolishing the property, and he's trying to construct. And even on the request of the applicants, he is not paying any heed to the request made by the applicants. And on that, the applicants have approached the police, and the police has the police, the officer in charge of his police station, and the police have called both the parties and have requested to maintain peace and tranquility. Moreover, the applicants have written to the deputy commissioner, but till now, no action has been taken by the deputy commissioner. But as per the the applicant, the opposite party appellant has filed a title suit, and in the title suit, the
You are the
civil
appellant.
judge.
You are the appellant.
I'm the applicant. The appellant is the appellant in the RFA is one Atikur, but he expired and he is substituted by his son.
What are you in the appeal? You are the respondent.
I'm non-respondent.
And in the trial court? In the trial court?
In the trial also respondent.
In the trial court, you are the defendant.
Yes, defendant.
Then what has happened to the suit?
The suit was decided in my favor.
In your favor?
In my favor.
So the plaintiff filed appeal.
The plaintiff filed appeal and
And that appeal is the RFA.
yes, Lordship.
And during the pendency of the appeal, the appellant is trying to demolish
Yes,
some of the
Lordship.
building.
Then demolish the building.
Okay.
In the title suit, he has been declared as a tenant.
Okay.
Tenant. And now, but the opposite party, the appellant, is demolishing the property and trying to reconstruct. So we have requested him to abstain on that, and we have requested, we have written a letter to the officer in charge of his police station. That is at Annexure 11, and Annexure 2, page 11. And in that respect, the officer in charge his police station has called both the parties and requested both the parties to maintain peace and tranquility. But he's continuing with his work. So the applicants, they have written to the DC also. That is at page 12, Annexure 3.
So what kind of order do you expect from this court?
Lordship, at this juncture, Lordship, to temporarily to grant temporary injunction on the respondent, the respondent appellant, not to go on with the construction work.
But we'll have to hear the other side also, isn't it?
Lordship, I was told that he was stuck in a traffic jam, Mr. Vikram Detmat.
Yes.
He was stuck in the traffic jam.
Let him come.
Lordship,
Okay, let him come. We'll take it up after some time.
Lordship.
Pass over the time being. Huh?
For admission, item number 2.
Please, my lords.
Yes.
I have received the affidavit filed by the state respondents 1 to 5 this morning, my lord, inside the courtroom.
Okay.
Now, my lord,
1, 2.
1, 2, 3, 4, and 5, my lord, state respondents.
When was it filed?
Your Lordship, on day before yesterday, Your Lordship.
This must be. Yes, so what is your submission?
May it please Your Lordships, as directed by this Honorable Court by order dated 22nd February 2023 and 15/3/2023. An affidavit for and on behalf of the respondent number 1 to 5 has been filed, bringing on records the action taken after issuance of the show cause notice and the amount of money released to the contractor following the issuance of the completion certificate by the then Executive Engineer, PEC Division. My
You are
lord,
Mr. L.T. Sankam?
yes, Your Lordship.
Okay.
After the issuance of the show cause notice, the respondent number 11 have replied to the show cause notice, which is at page number 14, Annexure C, Your Lordships. Thereafter, the state respondents have constituted an inquiry committee consisting of the following, which is at page 18, Annexure D, Your Lordships. May I read, Your Lordships?
Yes.
Office order dated 9 March 2023. The government of Nagaland is pleased to constitute an inquiry committee consisting of the following officials to look into the matter and to ascertain the facts of the case of issuing completion report dated 20th January 2014 for the work construction of road from Lipori to Molhekiam without completing the work by Engineer Apicha King while serving as Executive Engineer, PWT RNP PEC Division. Serial number, Shri Chinga Konyak, Joint Secretary to the Government of Nagaland, Works and Housing Department. Chairman, number 2, Engineer M. Z. Akho, Additional Chief Engineer, PWT Housing Member. Number 3, Engineer Sorai Miro, Superintendent Engineer, PWT RNP Member. The committee shall submit its report along with conclusive recommendations to the government within a period of 1 month from the date of issue of this order. That is 9 March 2023, Your Lordships. And we are waiting for the recommendations to be submitted, Your Lordships. And second, regarding the submission of financial status, which is at page number 19, Annexure E, Your Lordships. May I read, Your Lordships?
Yes.
To the Chief Engineer, PWD RNP Nagaland, Kohima, subject submission of financial status in construction of road from Lipori to Molhe Post. Sir, with reference to the above subject cited, I would like to state hearing that the total amount released against the work construction of road from Lipori to Molhe Post, 26 kilometer, under non-planned additionality after issue of the completion report is rupees 26.54 crores. The financial progress chart is enclosed herewith for your ready references. That is at page number 20. Is the annexure, Your Worship, chart. And as of now, 26.54 has been released to the contractor, Your Lordships.
As per the chart at page 20, the
Yes, sir.
up-to-date payment is 2619.88
Yes, Your Lordships.
and balance amount is nil.
That is out of 30 crore, Your Lordships.
Two six one nine and 2654. See, the amount released is 2654.
Your
And,
Lordships.
net up-to-date payment is 2619. Why it's not tallying? Two six five four is the net amount.
Your Lordships.
There's a deduction here.
Yes, Your Lordships.
There's a deduction. So basically, the issue is regarding construction of a particular road
Yes, Your Lordships.
and issuance of a completion certificate, despite the fact that the road was not completed.
Yes, Your Lordship.
So executive engineer had given the completion certificate on the basis of which the money has been released.
Yes, Your Lordships.
And the executive engineer says that he was asked to prepare the completion
Your
certificate by the then
Chief Engineer.
chief engineer
We-
on several occasions.
Yes, Your Lordship.
Ultimately, he gave in to that.
Yes, Your Lordships.
And who is that chief engineer?
He's no more.
He's no more.
Yes, Your Lordships.
So now by this office order of 9 March, an inquiry committee has been set up
Yes, Your Lordships.
to look into the matter,
Yes, Your Lordships.
and they will submit a report within 1 month.
Yes, Your Lordships.
Yes, what do you say?
My lord, here there are 3 road projects, my lord. They overlap each other. And my lord, one has been allotted to Nagaland Steels, which also that particular work order is also being executed by respondent number 7, that is the proprietor of Rhino Construction, El Meta. He is the attorney holder of that particular work order. So for 38 kilometers, work has been issued under the BMGSY. That work, my lord, I have received instruction from the petitioners that is going on. Now, my lord, there are other 2 work orders, my lord, which is not being covered by the 38 kilometers that falls under BMGSY. This is a big area, my lord, a range consisting of several villages within Miluri area under Pet district, my lord. Now, for the 2 work orders, the executive engineer, the then executive engineer, he issued completion certificate. And my lord, from here, what we can make out is that the committee has been constituted only to look into a matter concerning a particular work order. However, from the affidavit filed by the respondent number 7, affidavit which I have received on 14th of June, 2022, that 4.84 crores of rupees has also been received out of 5.69, for which completion certificate has also been issued by the same executive engineer. And my lord,
Show me that affidavit. Where is that?
I have received on 14/6/2022 affidavit filed by respondent number 7. Paragraph 5.
Just a minute. We're trying to locate the affidavit. Filed by?
Respondent number 7, the contractor.
Just check up. Have you mentioned that in your PIL? That it covers 3 work orders?
My lord, I have mentioned 2 in my initial PIL, my lord. And then later on, during the pendency of the PIL, it came to light that another work order has been issued to them, my lord. So I filed affidavit to that effect, my lord. And then again, my lord, another work order under the PMGSY has been issued to another contractor. However, my lord, that is not the subject matter of this PIL, but in that particular work has already been executed and successfully completed by the contractor, my lord. There are also 12 kilometers overlap with the present road concerning the present PIL. So I have stated in my affidavit filed before this honorable court that the respondent number 7 is trying to make it appear as if the work executed by the contractor, MS Fitulukense, was performed as if it was performed by him. Those 12 kilometers of they overlap with the PIL road.
Okay, we have the affidavit of 14 June. Where is that?
Paragraph 5, my lord. Paragraph 5 begins from page 3, my lord. I may be allowed to read it.
Yes.
That the statement made in paragraph 5 of the affidavit in reply is denied. Apparently, the document submitted by the affidavit in my affidavit in reply is a matter of records, and henceforth, if the petitioners have any doubts with regards to the documents, then they should go and approach the concerned authority to satisfy themselves. It may be stated that the road project from Aken to Star Lake only include earthwork in excavation of soil, earthwork in excavation of ordinary rock, earthwork in excavation of hard rock, construction of unlined surface drain, and construction of hume pipe 1000 mm dia and before culvert stop. As per the work order, the total cost of work is 5.69 crore, whereby the respondent, after execution of the above mentioned work, has submitted running bills, and the concerned department has released an amount of rupees 4.84 crore to the respondent. It may be mentioned that the progress of the work stands at 95% as on May 2022, whereby the present executive engineer PWD Road and Bridges has made a remark that physical progress is only of first cutting of earthwork in formation. Final finishing of formation cutting and some steep ingredient locations is yet to be executed. The respondent further states that the work is yet to be completed and a total of rupees 85 lakhs is still pending for the aforementioned project. As such, the claim made by the petitioner that no road has been constructed, neither any developmental works is undertaken, is false and incongruous. Next para, my lord. Here they speak about the other work order. With regard to the work from Lepori to Mole, the respondent humbly submits that the work includes site clearance, earthwork, site drain, road composition, cross drainage, and protection works. It may be submitted that the respondent is still executing the work, and the current progress of the work, as submitted by the present executive engineer PWD RNP PEC division, shows that a total of 11 kilometers has been completed from Kanchang to Aken. This, my lord, this Kanchang to Aken has been constructed by that MS Fitulukense. The total cost of the project from Lepori to Mole is rupees 30 crore, whereby an amount of rupees 26.54 has been withdrawn against the work, which includes deduction of 12% GST, 3% forest tax, and 6% as consultancy fee, and an amount of rupees 3.46 crore is still pending against the said work due to non-completion of the project. Now, after this, my lord, this honorable court constituted a committee and visited the site. Report has already been submitted before this honorable court. Appropriate orders has been passed.
Are you saying that this Kanjan to Aken road is not yet completed, despite the indication here?
Kanjang to Aken, my lord, this also falls under another PMGSY scheme, my lord, and as well as the present work order that has been issued to the respondent number 7. What I mean to say is that, my lord, there is overlapping. 2 or 3 work orders have been issued for that same road, my lord.
What are those roads?
My lord, I have also given a map in my petition, my lord. Now, the first PMGSY scheme, which has been awarded to Nagaland Steels, it starts from T01 and ends at Kalchang village. That is 38 kilometers. that the respondent number 7 is presently executing.
See, Mr. Counsel.
My lord.
There are already so many affidavits. So it's difficult to appreciate all these affidavits at one go.
My lord, then in that case, if the matter can come up next week, my lord, I'll also try to assist the court.
You'll
in
have
a
to
better manner.
simplify
My lord, my lord,
the issue.
my lord.
And that is one. Another thing is, in respect of this committee which has been formed,
Yes, my lord.
they say that within 1 month, the report should be submitted with
Yes.
suggestions.
Yes.
So that report will be available only in April, first week of April,
Yes,
second week or first week like that.
lordship.
So if that is being done,
Yes,
perhaps we should wait for that
my lord.
report.
My lord, my lord.
What kind of suggestions will be made?
My lord.
That will be important.
Yes, my lord. And my lord, what I want to point out is work order regarding to akin to Starlake, amounting to 5.69 crores. For that, also completion certificate has already been issued by the executive engineer, the same executive engineer. Not only for this 26 kilometers, that is for 15 kilometers. So for that, from this office order, no inquiry is being
See,
done.
we'll
Yes.
do one thing. We'll allow you to file one affidavit indicating what are those actual roads which have been
Lordship,
overlapped.
lordship.
What are those schemes and which have been overlapped? So that we can appreciate that.
My lord, my lord.
And as it is, the main thrust in the PIL is regarding one particular road, isn't it?
Yes.
What is that road?
It starts from G01 and ends at Molly Post. Molly Post is the last post within India, my lord. And then after that, Burma begins. Myanmar.
Is it called Lepori to Mole Camp?
Yes, Your Lordship.
Leporo to Mole Camp is one work order, my lord. Aken to Star Lake is one work order. G01 to Kangchang is one work order, my lord. And then,
All confining within this,
yes, my lord. And then they overlap each other.
all confining within this 01 to Lehori camp.
Yes, G01 Changshin to
G01.
Mole Post. The petitioners, they simply want good roads in their area, my lord. Even if completion certificate was issued and even if at all, if only the contractor had executed the work, my lord, then,
No, definitely.
My
We
lord.
should have good roads. It benefits the public, everyone.
My lord.
Yes.
Mr. Sintianger, the learned counsel for the petitioner, and Mr. L.T. Santan, the learned additional advocate general, for the state respondent number
1 to 5, Your Lordship.
1 to 5. Also heard, Mr. So-and-so, for the respondent number? For the respondent number 7. Stop. After hearing the parties, this court feels it necessary that the petitioner should file an affidavit incorporating a chart stating the roads which the contractor was supposed to construct, and the stretch of the road
Which overlaps.
which overlaps the original road, correct?
Yes.
Which overlaps the original road.
My lord, if it can be, if overlaps one another.
Which overlaps, okay, which overlaps one another on the road for which the work order was issued on, yes, the first work order
28/11/2011.
on 28
2011.
11/2011. Stop. We have also perused the affidavit dated 23/2023, filed by the state respondent number 1 to 5. Wherein the office order dated 9/3/2023 constituting inquiry committee of the officials of the department has been constituted to look into the matter and to ascertain the full facts of the case of issuing completion report dated 21/2014 for the work with an inverted construction of road from Lephori to Mulhe Camp without completing the works by engineer Abhijah King while serving as the executive engineer, PWD, R&B, PEC division. The committee has been asked to submit the report along with the conclusive recommendation to the government within a period of 1 month from the date of issue of the order. Stop. Considering that the office order issued by the Commissioner and Secretary to the Government of Nagaland constituting the committee has been given a month's time to submit the recommendations to the government. We deem it appropriate to fix the keys. On
We can have it in the last week of April, 24, no, 26.
on 26 for 2023. Stop. The learned additional AG shall file, sorry, on the next date fixed, the learned additional Advocate General shall file the affidavit enclosing the recommendations submitted by the committee to the government.
The chart also.
Yes. The petitioner shall also, on the next date fixed, file the affidavit incorporating the charge, incorporating the chart, stating the work, stating the original work allotted by the work order dated.
My lord, there are several work orders, my lord.
The original one,
It is
11,
28/11/2011.
28/11/2011,
11.
and the stretch of the road
Beginning from T01 to Mole Post.
and the stretch of the road where it overlaps, beginning from
T01
T01
to Mole Post,
to Molhe Post,
my lord.
listed accordingly.
Obliged, my lord.
Councillors come, yes, call it.
For motion, item number 1.
I beg apology, my lordship,
That's okay.
for the delay.
Lordship, Ms. Lordship.
Yes.
Lordship, I've just spoken with my senior on the phone in respect to the RFA. Lordship, this matter was filed in the year 2011. And he informed me that during those times, RFA this matter is a transfer matter from the principal bench on top. So with regard to that,
Why is this RFA before division bench?
Lordship,
That's what we want.
yeah, Lordship, actually, even I do not have practical knowledge about it. Actually, when the case was filed, it was, the principal counsel was Sir Khatania from Gauhati. And the case was going on, and after some proceedings, it was dismissed for non-prosecution also. Then it was also before the division bench. After that, the case was, again, the appeal was restored. It was before the division bench. So my father was pursuing the case. Unfortunately, he's no more. So, Lordship, I do not have practical idea. So I have to go through the file for that. If your Lordships permit me, please.
Okay.
Lordship.
So keep that in mind. You
Lordship.
must address the court why it's before the division bench.
Lordship.
Lordship.
Because I don't find this practice in other places.
Lordship.
RFA is heard by a single bench.
Lordship.
So what do you say about this IA?
Lordship, actually,
You are demolishing the building.
No, Lordship,
Given the
actually-
pendency of the appeal.
No, Lordship, actually, I have received the IA yesterday itself. Actually, the fact of the case was the appellant, he's running a shop in the suit premises. And that shop, it was under a grant permit issued by the state of Nagaland to his grandfather. And after the demise of his grandfather, the father of the appellant is running the shop. And after his demise, he is continuing the shop. But then a few days back, as it is since 1963, the Assam type house, some part of the roof, it has fallen down, as he told me. And then while seeing so, he just thought of renovating it. And when the labor, he just came and saw the roof condition, while touching it just fell down. And this is the thing. And yeah, I do understand that status quo was there and he should not have touched the roof like that. However, I have to gather information from my client with regard to this, Lordship. And if I may be allowed to reply to their IA.
Surely you'll get a chance to reply.
Lordship.
Meanwhile, you don't do anything.
No,
Status quo will be there.
yes.
Status quo
Everything
will be
is
there.
stopped, Lordship.
See, the main appeal is of 2011.
Lordship.
You should try to get it disposed of,
Lordship.
isn't it?
Yes, Lordship.
Either this way or that way, it has to end sometime.
Lordship.
It cannot go on like that.
Lordship.
Yes, Lordship.
The property is falling apart
Yes,
and the people are still litigating.
Lordship.
Brother, we'll do one thing. We'll give them chance. 2 weeks time to file objection. Any status quo may be maintained. What do you say? Heard Mr. Foseko Fote, learned counsel for the applicant. Stroke respondent. Number.
Respondents 1 to 11, Lordship. In the appeal,
Respondent numbers 1 to 11.
Lordship.
That means applicants.
The applicants, yes, Lordship.
You
The
are more than
applicants-
one, isn't it?
Yes, more than one.
Okay.
The committee,
Yes, applicants, stroke respondents, so and so. 1 to 11.
1 to 11.
Stop by filing this application under section 151, read with order 39, rule 1 of the Code of Civil Procedure, 1908, the applicants pray for injunction to restrain the opposite party from demolishing the existing structure and also from undertaking fresh construction. Stop. According to the applicants, the opposite party, stroke appellant, where's the averment in your IA?
Paragraph 4, Lordship.
On 12/3/2023, without obtaining any permission from the court or from the competent authority, started demolishing the structure of the property in question. Stop. As a result, the applicants had to approach the police
Lordship.
by filing an FIR on 12/3/2023 before the East Police Station, Dimapur.
Lordship.
Stop. The police authorities thereafter called the parties and asked them to maintain peace and asked the opposite party not to proceed with further demolition, oblique construction, without the permission of the court. Stop. Despite the same, the opposite party has continued to demolish the building, and for which the applicants also approached the
DC, Lordship.
Deputy Commissioner.
On 13/3/2023.
Where have you stated that? On 13/3/2023.
Lordship. That is at the
Deputy
subparagraph.
Deputy Commissioner, Dimapur, Nagaland, huh? On 13/3/2023. To stop. To stop. Despite the same, the opposite parties are adamant in carrying out the demolition and construction. Stop. As such, the applicants have approached this court through this interlocutory application. Issue notice to the respondent, returnable by 2 weeks. Mr.
V. Devnath.
V. Devnath, learned counsel, appears for the respondent and submits that he may be allowed to file objection to the interlocutory application. Prayer is allowed. List this matter again after 2 weeks on a date to be fixed by the registry.
Lordship.
In the meantime,
Lordship, can it be 3 weeks, Lordship? 3 weeks.
3 weeks. All right, 3 weeks.
Thank you, Lordship.
Returnable by 3 weeks. Huh? List the matter again after 3 weeks on a date to be fixed by the registry. You are outstation or from Dimapur?
From Dimapur.
Then it's okay. List again after 3 weeks on a date to be fixed by the registry. In the meantime, the parties are directed to maintain status quo. All right. Status quo is on today, huh? All right. Next.
For admission, item number 3 and 4.
May it please your lordships. Item number 3 and 4, actually there were 2 writ petitions, 5 writ petitions, all were disposed of by a common judgment and order. Out of that 2 writ petitioners, they had filed item number 3, that is writ appeal 4 of 21.
Okay.
Item number 3. Now what has happened, actually 2 writ appeals should have been filed. So item number 4 is a second writ appeal filed by the appellant number 2 of item number 3. For disposal of this matter, my lords, item number 3 can be taken. All the papers are there of both the petitioners. Item number 3, that is writ appeal 4 of 21.
4 of 21 was the original writ appeal.
Original. Just for
And,
technicalities,
and from there,
both the writ petitions are here.
the appellant number 2 has been deleted.
Two.
Correct.
appellant
Appellant number 2 has been
Deleted. And she has filed
She has filed this writ
4 of
appeal
22.
4 of 22.
But all the papers of both the cases are in the 4 of 21.
Why two separate appeals?
Because, my lord, the original writ petitions were 2. For some inadvertent error, only 1 writ appeal was filed by both the appellants. Original writ petitions challenging their termination were in 2 separate writ petitions.
There were 2 writ petitions.
2 writ petitions.
Disposed of by a common
Judgment. So there should have been actually 2 writ appeals. But somehow 1 writ appeal was filed. Just for technicalities, it was made 2 writ appeals later on. But for consideration of all this case, writ appeal 4 of 21 can be taken. All the papers are there.
All right.
Now, Chief, what has happened in this writ petition? The writ petitioners were working in 2 separate departments. Where Mr. Kevin, he was working as a paramedical in Health and Family Welfare Department. He was appointed there in 2011. 2013, he filed a representation before the Commissioner of Transport Department stating, I want to go on deputation in the Tourism Department. Because there were some vacancies arising for promotion and retirement. So he said, I want to go on deputation.
Just a minute. Okay. Who's for the other side? Ms. Shukra is there.
Yes. No.
This is listed for what today?
Admission.
Admission.
For admission.
Yes.
Okay. Just give me the case number. What was the case number? Writ petition, WPC?
11K of 2021.
By whom?
That was by Kevin.
Kevin
Guttosos Sekhos.
Okay. Then the other one?
That other one is 21K of 2019.
2019.
Yeah, 11K and 2119.
By whom?
That was by...
No, Your Lordship, 11 is by VB Zonyo Ndan.
Yeah.
And 21 is by Kevin
Kevin.
Mutua.
Yes.
Okay. Then judgment, common judgment?
Common judgment is dated 12/3/2021.
Then writ appeal number?
4 of 21 was filed by both the parties.
Now it is by whom?
4 of 21 was filed both the parties. Subsequently, petitioner of 11, she filed another, that is 4 of 2022.
Now writ appeal 4 of 21 is by whom?
Kevin.
Okay. Then writ appeal 4 of
2022 is by, my lord, I couldn't pronounce the names, I'm sorry.
Okay. VB
Zono Endang. Nadang.
So although they were together, now they are separated.
They are separated.
But they're having the same number, 4 of 21 and 4 of 22.
1 year apart.
Okay. Now you want us to look into 4 of 2022.
21. It has all the papers that will suffice for both the cases.
All right. Yes, please.
Before going into the papers, I have a very limited prayer. In fact, in my petition also, prayer was very limited. What has happened? These 2 persons were working. Kevin was working in Health and Family Welfare Department as a paramedical worker. Paramedical. And Srimati Endang was working as a LDA computer assistant in Transport Department, Nagaland Transport Department.
LDA transport, computer assistant.
Computer assistant. They were substantive regular posts, both of them.
They were working on what? Contract basis?
No. Substantive regular posts.
Substantive appointment?
Yes.
Okay.
Subsequently, what has happened? Some vacancies are arising in the tourism department for the post of tourist officer. Nothing was done. Those vacancies were still there.
We are concerned with the post of tourist
officer.
Both the writ petitions. Tourist officer.
In tourism department.
Okay.
Now there were some vacancies available, but they were not filled up. What has happened is petitioners had filed representations that we want to go on deputation as tourist officers for that post.
Okay.
Files were processed. There was some due process that has happened. Even the approval of the chief minister was there, honorable chief minister of that time, and they were given that on a deputation, you were working as tourist officer in that department, in tourism department from 2016. In 2016. Later on, they were regularized in that post.
Oh, these two petitioners.
These two petitioners.
They went on deputation
They were on deputation.
as tourist officer.
Tourist officers. No objections were given by the parent department.
Okay.
They were regularized in that post.
I see.
Tourist officer. Some complaints had been filed by some petition, other persons and all. Admittedly, my lord, to become a tourist officer, the eligibility criteria is you need to have a bachelor degree or a diploma in hospitality, catering, or tourism related studies. We do not have that. It is admitted. Now, what has happened 2016, I was regularized. These complaints, even FIRs were filed saying that there's a backdoor entries has happened. I have not been made accused in those FIRs. In fact, some high-level officials trial may start there. There's a pleaded case of the respondents, state respondents, that although we were given the office of post of tourist officers, we never joined there. We were drawing our pay from the earlier department. From our parent department, for Kevin it was health and family welfare. For Mrs. Srimati Andang, it was.
While on deputation, you were drawing your pay from your parent department. But you were regularized.
That is a problem.
After regularization, then?
Still we were drawing.
Still you were drawing?
Still we were drawing. Now, why it has happened, I cannot improve these things. These are facts. This has happened.
You should not improve.
I should not improve.
You have come to before a court of equity.
Yes,
so
my lord.
you have to lay down. You have to lay out.
Yes, my lord.
All the cards. You cannot hide some.
No, 2016, we were regularized. 18, what has happened? Since we are regular, we cannot hold two posts. We were made to resign our earlier post, from parent department. We resigned in that post of 2018, in 2018, with the hope that now our salaries will come from tourism department. But from 18, we have not received any salaries.
From?
Not received any salaries from any department.
From which year?
18.
2018.
18. There are separate repetitions filed for that. They are not subject matter of this. 2019 January, 29 January 2019, Vigilance, 16 January 2019, Vigilance says that there are 5 officials, 5 appointments. We find something fishy there. They should be looked into. The Transport Department, by 29/1/2019, terminates us. Tourism Department, without giving us an opportunity of being heard. No show cause, no notice, nothing.
Tourism.
Okay. Now,
see, the person who was LDA computer assistant was from which department?
Transport Department, Nagaland Transport.
Transport, okay. Then you were terminated.
Terminated, both of them.
When were you terminated?
29/1/2019. Both the persons.
By whom?
Tourism Department. Termination order was by the Secretary of Government of Nagaland.
Is that what you have challenged in this writ petition?
Writ petition was challenged on that basis. Writ petition said that we were not given an opportunity. We were not heard. We were on lien. We wanted to come as on deputation. We had never applied. We have never said that regularize us. But they had regularized us. We had to let go of our earlier substantive post. We had to resign. We cannot hold 2 posts. We had to resign. It is the admitted stand that till 2018, we had been drawing salary from our parent departments. It's a pleaded case of the respondents in their affidavit in opposition.
Okay, so you were terminated in 2019.
19.
That is why you filed this writ petition 11 and 21.
Writ petition, yes. Writ petition was disposed on a single ground. On a single ground, if I come to the impugned judgment.
It was dismissed or disposed?
Disposed.
How? Dismissed.
Dismissed.
That is why the appeal.
That is why the appeal. If your lordship comes to page 35 of the appeal memo. 35, para 13. As stated already, service rules of 14, that is the Nagaland tourism rules, also provides for method of direct recruitment, that is 25% via direct recruitment, 75% with departmental promotion from lower grade. It is also provided that direct recruitment has to be conducted by the NPSC. This was not done, and the same would consist of written and interview. However, in the case of the petitioners, though they were appointed directly, the method of recruitment was not followed, and the recruitment was not through NPSC. Secondly, they are neither from the lower grade of the department that can be promoted. Therefore, the method of recruitment and the manner in which the same should be conducted as prescribed in the rules has been completely brushed aside in the case of the petitioners. As such, I find no ground or reason to uphold such an appointment orders to protect them, even for a moment, for the sake of issuing a show cause notice or for giving a chance of being heard, because doing that would at best amount to only serve formalities. Second, next paragraph, paragraph 14. It states about 1416 violation. Down below, my lord, there's a citation that has been quoted. Therefore, it is clear, if your lordship finds, 7th line from bottom. Therefore, it is a clear case of violation of Article 14 and 16 of Constitution. In the case of state versus so-and-so, reported in so-and-so, it was observed by Honorable Supreme Court at para 22 of the judgment that where the facts are admitted, the principle of natural justice were not required to comply with, particularly when the same would result in futility. Now, this judgment, the later part of this same paragraph says, however, if I'll place the judgment, however, if some process has been taken while appointment to uphold natural justice, opportunity has to be given. If I may place that judgment. That part was
which judgment?
This judgment that has been quoted.
State of Manipur.
State of Manipur.
Why Token Singh?
Yes.
It's a single bench or division bench?
It's a Supreme Court judgment, division bench judgment.
Huh?
Supreme Court judgment.
Oh, Supreme Court.
Supreme Court.
Okay.
If your lordship comes directly to paragraph 22, which has been relied by the Honorable Single Judge. Paragraph 22. I'll read the whole paragraph. The respondents, therefore, in our opinion, were not entitled to hold the posts. In a case of this nature, where the facts are admitted, the principles of natural justice were not required to be complied with, particularly when the same would result in futility. The single judge stops here. It is true that where appointments had been made by a competent authority, or at least some steps have been taken in that behalf, the principles of natural justice are required to be complied with in view of the decision of this court in so and so. This portion was not taken into consideration. I was not even afforded. Now, where I'm placed, I had to resign my earlier post because, yes, I cannot hold two posts. I wanted to come for deputation. You regularized me. Rightly, wrongly, you regularized me. It's a government decision which had the approval of the Honorable Chief Minister. You regularized me. Now I am nowhere. My earlier post is also gone, which was a substantive post. And single judge is silent about that post, about that. He has not stated anything. It is a pleaded case of the respondents. If I may show your lordship.
See, what you're trying to impress upon the court is that some steps were taken.
Yes.
What are those steps? The steps is that you were sent on deputation. Pay was received from that department.
Yes.
Later on, you were regularized.
Lordship.
All those things that had not been considered. So it's not that you were suddenly brought up from somewhere and put there.
Exactly.
That is why at least the minimum chance of being heard should have been afforded to you.
Yes.
So for that reason, the first part of paragraph 22 does not say anything, but the second part
says,
clearly says that you should be given chance.
If some process has been taken, and the process that has been taken has come up from the affidavit in opposition that they have filed. They have given all the notings of the file. And more so, my lord, I wanted to go for deputation. I'm still urging, I wanted to go for deputation. There is not a petition, not a application on record that regularized me.
So let us go back to the judgment. What else, according to you, is not correct?
My lord, I had challenged my termination order on the ground that I was not afforded a reason. This judgment disposes another 3 repetitions. I am not concerned with that. Para 13 and 14 is in respect of me. Both the petitioners. He has simply stated, the learned single judge has simply stated that it would be an exercise in futility had we be given that chance. If we would ever have been given that chance, we could have said that we never wanted this post to be, we never wanted to be regularized in this post. Send us back to our original post. That was a substantive post. Now I am nowhere. And the process that has been taken up in appointing me, Your Lordship will point out from their pleading, their affidavit. If Your Lordship comes to page 68,
Yes.
Your Lordship will come to page 71 first.
71.
If I take Your Lordship to 71, it will be apparent. 71, date is down below, my lord, 4th of March 2013. This is for Kevin. Application for the post of tourist officer. With due respect, humble submit, I have the honor to lay down few lines for prayer for your consideration and sympathetic order. That, sir, having learned a post of tourist officer caused by retirement and promotion, resultant vacancy of the officials of the directorate is likely to arise in the near future. As I would like to offer myself as one candidate for the same on deputation, my particulars for support of the candidature are given below. These are my particulars. I have said it in 2013. This file was processed. Down below are the forwardings and all. If Your Lordship comes to the next page, that is sent forwarded, referring to the subject cited above, I have the honor to forward herewith the application in respect of so-and-so who is applying for the post of tourist officer on deputation along with NOC from the Department of Health and Family Welfare. Next page is the NOC from the Health and Family Welfare. Subsequent page, that is of page 74. These are the file notings that has happened. The government has looked into this process. After all this, page number 77. Is the temporary appointment as my regular appointment was temporary appointment regularized as tourist officer. Some process was taken. If Your Lordship sees the preceding pages, some process was taken. Rightly, wrongly, a process had happened.
No, the process was for deputation.
Deputation.
But you have been regularized.
No, deputation order is there, madam.
Where is
Page 68. Deputation order is at page 68.
This is the first order?
First order of deputation. Appointment is made in creation of post approved as so. The appointment is made on temporary basis against clearing and the other certified the cabinet the director Nagaland. This is issued in favor of by Honorable Chief Minister of Nagaland. This was my deputation order. Subsequently, it was regularized.
No, but 68, isn't it?
68.
68.
68.
But where's the word deputation?
Word is not a temporary basis. Appointment made on temporary basis. I applied for deputation.
Maybe.
But
But your appointment is not deputation.
It is on temporary basis. That is what, my lord, that is what I'm urging. There is a notification, government notification that they have annexed. There's a ban that no contractual employees should be taken of 2016. Rightly, I am not opposing that notification. My application shows I wanted to go for deputation. My parent department gives in NOC that we do not have any problem if he goes for deputation.
No, all that is okay. Because
No one is okay.
There are few ingredients for deputation, you know. The borrowing department, the person concerned, and the person who's going to lend it, department, all have to agree.
Agree.
Then deputation takes place.
Exactly.
Usually about 3 years.
Lending
And maybe extended again another year or two like that. Ultimately, come back to your own parent department. But here is a case, you have submitted your willingness for deputation.
With NOC from my parent department.
And NOC by the parent department for deputation.
Deputation.
But you were appointed.
Appointed.
That is a bit different.
I understand my peculiar set of facts. But what boils down, you have terminated me without affording a reason, affording an opportunity of being heard. Now, my lord, suppose before my termination of 29/1/2019,
Where is the absorption mode?
my lord,
You have been absorbed or
no,
regularized?
regularized. I showed your lordship that.
77.
77. Excuse me.
Regularize. The facts are similar to the other person also.
Exactly. If
Kevin.
my lord comes to page 78, this is intergovernment communication. These are about the two petitioners. In reference to the subject indicated above, the undersigned is directed to bring your notice that these two applicants from two different departments applying for deputation to the Department of Tourism as tourist officers, both having the requisite experience and expertise to work in the department so sought of hearing. Their particulars are, with reference to their place of work and designations, may be summarized as below. This was given. I cannot claim the post of tourist officer because I do not have requisite qualifications. That I have to admit that. But I have lost my actual post in which I was earlier.
Deputation is possible.
Deputation is possible. I'm
Possible.
deputation, no,
You need-
I understand.
You need not have a
Yes,
qualification.
yes. For deputation, it's a stopgap
You are
arrangement.
already working somewhere, so
Yes, yes.
somebody feels that you should come there for work.
Stopgap
sometime.
arrangement.
So
Stopgap
the arrangement
arrangement.
is there.
It can be done.
But for a person to be appointed on that particular post, definitely he has to have the qualification.
I understand, my lord.
If it's
I was
by the
absorbed.
regular-
If I have been absorbed, if I was absorbed, which has happened here, the Supreme Court judgment of 2007 says that no, giving a representation, hearing you is a futility, provided some process has been taken. Now that part has been not considered by the honorable single judge. A process had been taken.
Where is your termination?
My lord, page 54, if your lordship comes. This is for Kevin, and similar order for the other lady.
54.
54 of the appeal memo. 29 January 2019. To Sri so-and-so, whereas you were appointed as tourist officer under Department of Tourism by order dated so-and-so, and whereas your appointment as tourist officer had been investigated by the Vigilance Commission, Directorate of so-and-so, and found out that you have illegally been appointed by Tourism Department in gross violation of established government norms and procedures, and whereas Department of Personal and Administrative Reforms has conveyed the decision to the government to terminate your service, now therefore the appointment order dated so-and-so is hereby nullified and your service stands terminated with immediate effect.
This is in respect of
Kevin.
Kevin. The other petitioner?
Other petitioner, my lord, somehow that same order is not reflected in the records. I don't know why, but it's the same order of 29 January 2019. Same order. Because if your lordship comes to the previous page, previous page, it says it's from the Joint Director of Nagaland. I am to hereby refer as cited above to convey the decision of the government to terminate the services of 2 tourist officers and 5 transport tourist assistants who have been identified by Vigilance Commission, so-and-so, so-and-so, so-and-so. For some reason, I don't know, by inadvertent error or something, Mrs. Simati Endang's order is not on record.
It's not there in the other appeal also.
They're also not there. But it's the same exact order. My instruction, it is the same exact order, same date.
You have made a statement to that effect in your writ petition?
No, my lord. That is not there.
No, then?
Somehow, I don't know, somehow it was missed while filing the writ petition, but it was stated that we want a quashing of that. I don't know why it has happened. I'm extremely sorry for that.
WPC 11. 11K. You have not made any statement that you have been terminated.
I have made a statement. I have made
That
a
is what I was
statement.
asking you.
Oh,
You may not have the document, but maybe.
I have been 113. 117, I guess. My lord, page 116. Para 14 we have stated. And 15 also we have stated.
No, this is a submission.
My lord, will come to page 12, para 12 then. Petitioner begs to say that petitioner was a regular employee and therefore petitioner is entitled to make necessary reply if the respondent authorities decide to take any action. As already stated, neither any departmental required nor disciplinary procedure has been initiated against the petitioner. However, no show cause whatsoever was issued to the petitioner before issuing the termination order.
This is also,
And 10, paragraph 10.
no, I think paragraph 9.
9 and 10. My lord, the impugned termination annexure 8 is mentioned here, but somehow it is not on record.
No, that's okay. I just wanted to know that whether you made some statements. So in fact, there was, annexure 8 was there in the writ petition, isn't
Writ
it?
petition, it was there, but I don't know why it missed in this, both the appeals. But it's the same order. Same date, same order, name is different.
Then where is your resignation?
That is also not on record, my lord. That is not, but we have given a pleading that we have resigned.
Those ingredients are not on record, and what do you expect us to appreciate them?
My lord, will come to page 57 then. I'll point it out. Page 57. This is the state government's affidavit. My lord, got it? Point 6. All along, the petitioner has been drawing his salary from the Health and Family Welfare Department till 2018. 7. Records prove that the petitioner never joined the tourism department and his name was never shown in the list of payroll of gazette officers in the tourism department for the years 16, 17 and March 18. Their stand is, I never joined. That be the case, I can very well say, how can tourism department terminate me? I was not paid by the tourism department. That is what their stand should have been. And in my affidavit in reply, I have stated that I have given resignation. That is at para 90, page 90. Point number I. Petitioner submitted another joining report in the later part of 18 after resigning from the post of paramedical worker for short PMW in the month of October 18 in the Health and Family Welfare Department, and since then the petitioner has been regularly attending office till date. However, petitioner was not allowed to sign the attendance register till August 19. Petitioner has been allowed to sign in the attendance register only after the month of September 19 till date. Madam, there's a lot of mismatch of facts, no doubt about it. But it is admitted by both the parties, we wanted to go on deputation. And it is an admitted case, we were not heard before terminating. Whatever may be the reason. We could have very well stated in the, send us back to our original department.
The resignation
letters are not
letter is not there.
Letters not there. October 2018, both. It is their case, my lord, page 59. Again, if I may point out to your lordship, page 59 of the affidavit in opposition by the state. My lord, third paragraph. There's no paragraph number, but third paragraph. Petitioner was initially appointed as paramedical worker by so-and-so, dated so-and-so, under the establishment of Health and Family Welfare. Petitioner is working in the Health and Family Welfare Department as paramedical so-and-so, and when he was given appointment as tourism officer, backdating the date of his appointment to 4/6/2016. Petitioner has not worked a single day in the Department of Tourism and thus has not drawn salary. As such, petitioner cannot be stated to be a regular employee in the department. Payrolls maintained by the Director of Tourism does not show the petitioner's name in the date of appointment. Petitioner was listed in the payroll of Department of Health and Family Welfare, drawing salary and allowances from the Health and Family Welfare till 2018. My limited prayer, my lord, I was not heard. I could have very well asked, put me back to my original parent department.
one thing is that you don't dispute the fact that you resigned.
I resigned. That's
You
a fact.
resigned from the department, parent department.
There is an
And
issue,
on
my
the
lord.
other hand, the tourism department says that you
I am
never
not
worked.
available. Exactly.
So where were you?
Exactly, my lord. Exactly, that is the point. And if I have not worked, my lord, if I have not worked in
You're
tourism
neither
department,
here nor there.
if I have not worked in tourism department, how can you terminate me from tourism department?
Anyway, we'll come back. Give us 5 minutes. All right, we'll just come back. Yes, where were we? Page 59.
Page 59. Now, the third paragraph. The petitioner was initially appointed as paramedical worker by the order dated so-and-so on the establishment of health and family welfare. Petitioner is working in the Department of Health and Family Welfare as paramedical worker when he was given appointment as tourism officer, backdating the date of his appointment to 4/6/2016. The petitioner has not worked a single day in the Department of Tourism, thus does not draw salary. As such, petitioner cannot be stated to be a regular employee of the department. If I am not a regular employee of the department, if I am not working there, how does the tourism department cancel my termination?
Okay,
Give me termination.
one thing, you see, it says backdated. What do you mean by that backdated?
It is their allegation. It is the state's allegation that when our appointment was given, some of our relatives were in the high post of tourism department. But they say it is backdated. Things have not been brought on.
No, backdated from which date to which date?
Exactly. It is not on record. It is their period case. I'm reading their affidavit.
No, I understand. To your understanding, what would be the backdate? Is there any backdate?
I had applied in 2013 for deputation. I had applied for 2013 deputation. My deputation was being considered. File was moving around for deputation, and they had given me a temporary appointment now.
That was in 2016.
16.
And they say it's backdated. Backdated. Otherwise, your appointment was as paramedical worker in 2011.
11.
So 11 to 2016, before appointment, you are the paramedical worker in the health department.
Health and Family Welfare Department.
So 2016 onwards, you came over to the tourism department. Till you were terminated on
29/1/2019.
16 to 19. Almost 3 years.
Almost 3 years.
But they say that you never worked in tourism department.
And exactly same stand in the other writ petition.
You never worked in the tourism department.
I state that I was working in the tourism department, but I was drawing my salary from the earlier department because I was on deputation.
In the tourism department.
Tourist officer in tourism department.
Where are you working?
That is my stand. I was working.
Where? In the directorate or in the secretariat or where?
Directorate. Because my appointment says directorate. Absorbed as directorate. And exactly by the same case, if your lordship comes to page 132, the affidavit in opposition in the other for the Miss Simati and
Directorate. And this affidavit is filed by the joint secretary.
Joint secretary.
He says that he never worked one single day also.
Never worked. And we were drawing our salary from the parent department.
And salary wise, of course, tourism was not disturbed. You were getting salary from the transport department.
Transport for the other lady for
Kevin is from health.
If your lordship tell his page 57 and 132. Page 57 and 132 of the same of the appeal memo. If your lordship tell is that.
132.
132 is the affidavit in opposition for the other petitioner. Same, point 6 of 132 says, all along petitioner was drawing her salary as LDA cum computer assistant from the Nagaland Transport Department, Dimapur Station till 2018. Point 7, petitioner never joined nor served the tourism department and her name was never shown in the list of payroll of Gazette officer of tourism department for the years 16, 17 and March 18. Then comes the next page. Page 134. Here is another twist, my lord. Second paragraph. It may be pointed that the petitioner was appointed twice to the same post of tourism officer on 4/6/16 on temporary basis as claimed by her and also on 19/9/17 on temporary basis with a fixed pay of so and so, so and so, so and so. The appointment order stands to prove that the appointment dated 4/6/2000 was backdated. Petitioner is working in NST Department LDA where she was given appointment as tourist officer backdating the date of appointment to 4/6/16. Petitioner has not worked a single day in the Department of Tourism and thus has not drawn salary. As such, petitioner cannot be stated to be a regular employee in the department. On one hand, you are saying I have never worked there. And on the other hand, my termination is from that post. How can it be? And in the midst of all this, I was made to resign from my substantive post. I have to resign. I cannot hold two posts on being the same person.
But where is that government?
My lord.
Where
I
is
have
that
resigned,
government
that I have resigned.
you were asked to resign?
I had to because I have till 2008.
Let us see what you said in the writ petition.
Writ petition, I do not say about resigning.
Then?
In the affidavit in reply, I state about resigning.
Why not in the main writ petition?
My lord, writ petition, certain things were not right.
No.
Pleaded. I do admit.
Why you have not pleaded these things in the writ petition?
I do admit, my
What
lord.
was the challenge made in the writ petition?
Termination order.
Termination
Only
order.
termination order dated
So,
29/1/19.
how do you build up your case that you were wrongly terminated? Of course, one of the ingredients has to be that, see, I was there, then I was given here.
Yes.
And now from here I've been terminated.
My
At best, even if you terminate me, I should be put back in that place.
That was not
And
my.
why is that? Because I've been asked to submit my resignation there because you're working here. You resigned there.
My case before the learned single judge was.
I mean, that any prudent person, ordinarily, that would be your case.
Yes, my lord.
I've been asked to resign, so I came here. They said you resigned, then I resigned. You should have said that.
I understand, my lord. Before the learned single judge, my prayer in the writ petition was, I was not heard before issuing my termination letter. That's it. I was not heard, and apparently the learned single judge confirms it that it would have been a futility.
So that was the only issue.
That was the only. He has not gone into the fact that whether I should have given the proper hearing or not. He has rather said my appointment is illegal.
See, Mr. Counsel, your writ petition also is only from page 44 to 49.
I understand, my lord. Yes.
45, 44, 45, 46, 47, 48, 49. 6 pages writ petition.
I understand, my lord. I cannot improve on that. I understand. If your lordship sees my writ petition, what is the prayer in the writ petition? What is the prayer in the writ petition? Page 49. Page 49, in the premises aforesaid, it is most respectfully prayed that your lordship will graciously quash and set aside the government decision dated so and so, that is from the Vigilance Department, issued by the Joint Secretary Government of Nagaland of PNR, the Personal Department, and quash and set aside the impugned termination order issued by Secretary. This is my prayer. Because I was not heard. My simple prayer before the learned single judge was, quash it because I was not heard.
So where's annexure C and D? C is that you have shown me that page 53.
53 is that order from the.
And D is
the termination order.
Termination order. Okay.
I have just stated that my termination was illegal. It is who they have come up in their affidavit stating I never worked there. In fact, my lord, the documents that I have relied showing that some process was happening for my deputation, those documents were annexed by the state respondents. The file notings were given by state respondents. And the Supreme Court judgment, which the Honorable Learned Single Judge relies while dismissing the petition, the second part of that paragraph 22 says that if some processes happen, an appointment was given by some competent authority, natural justice comes in.
Let us just appreciate the annexure A onwards of the writ petition.
Yes, my lord. Page 51.
51. This is your appointment.
Yes, this is my temporary appointment.
As tourist officer.
Tourist officer.
Then annexure B is the
regularization. Annexure C
2016 and 2017.
Yes. Annexure C is the
Yes, annexure A is the appointment, B is the confirmation,
C is the
regularization, C is the letter which says that Vigilance
Some
Commission
five.
report.
Yes, my lord, it states of 5 officers. If your lordship says 2 tourist officers and 5 tourist assistants, no one is named. No one is named. Next page, my lord. Total known application of mine on the part of the authority. If your my lord sees the second paragraph, and whereas your appointment as tourist officer has been investigated by Vigilance Commission, Nagaland, and found that you have been illegally appointed. That much. Second, and whereas Department of Personnel so and so has conveyed the decision to terminate your service, and that's why I'm terminating. So this is done by the Secretary of Tourism Department. They have not applied their mind whether I should be considered for given an opportunity of hearing or whatever. The personnel department says terminate them, they terminated without affording me a reason.
See, there is one settled principle of law also. If the very appointment is void ab initio,
I understand.
then
My lord,
we have to speak the same language.
My main thing is
Same door you go, same door you enter, same door you have to go
then
back.
I come back again to that same judgment, my lord. I come back again to that same judgment relied by single
That process you're saying, what is
Yes.
that process? In your case, is that the few communications here that I want to go there, they said no objection. And do they invite you also? Come?
No.
No.
And those are their case. They have shown the process. I have applied for deputation. My lordship will see that I had applied for deputation. There is nothing on record to show I wanted to be absorbed.
But those are not the those are not the things which have been highlighted in your writ petition.
I understand, my lord. I understand it. I
So can we go like this?
my
in
lord,
writ-
226 lordship can go for to the
No.
sky.
So writ appeal is an intra-court appeal.
I understand, my lord.
You know.
I understand.
We are just here to see whether it was
Right or wrong.
rightly passed or not. That's all.
Then
Whatever reasoning may be given, we are not saying that this reason will be better, that reason will be, this is not better.
Then
This is
what has
better.
fallen
That cannot
for
be
your
done.
lordship?
We cannot substitute our view.
I understand, my lord. What has fallen from your lordship? If I had been given an opportunity, if at all I had been given an opportunity to see these things have come up, your regularization, your appointment is illegal, what do you have to say before termination? If I would have stated my facts in the representation. Government could have looked into it. And the gamut of the thing is, I have lost my substantial post. I wanted to come for deputation. You should not have given me deputation.
That is not your case in the writ petition.
I agree to your lordship. I agree that. But matter remains, I was not heard, and that was my only challenge. And the learned single judge in that same paragraph had said, giving me an opportunity of being heard will be a futility. But there is something in the petition, and the case is, my case has been more fortified by their evidence, affidavit in opposition. On one hand, they are saying that I never joined tourism department. Admittedly, till 18, I was drawing salary from our parent department. If I have never joined tourism department, how can you terminate me from tourism department? This is an equity court. Simple as that.
You start your paragraph with that I was appointed temporarily in tourism department. Only somehow in the affidavit something comes up.
Yes, my
okay, he has this background, that background.
Yes, my lord. Yeah,
But your main thrust of your writ petition was that you have been wrongly terminated without
Wrongly
giving any
terminated.
chance.
Wrong,
That's-
yes.
Yes, we'll hear anything else you want
My
to add?
simple prayer, my lord, at least I may be allowed to give a representation to the government. At least my case may be considered. My simple prayer. And yes, I do not have requisite qualification for this post. I admit that.
But have you tried?
My lord?
Have you tried?
No.
Before the government, see, I've been sent from here to there, not of my choice. I've been terminated. Now, at least
No, my lord,
you
no.
take me back.
Once terminated, I just filed this writ petition.
You have not attempted.
No. After termination, I filed this writ petition.
All right, let's hear Mr. Shukri.
Please, Lordship, Lordship, it is a very sad thing that a person who obtain appointment as well as regularization by fraud, approaching again this court, trying to manipulate this and that, showing your Lordship that the single judge has erroneously decided the case. Lordship, it was never the case of the petitioner before the learned single judge that he was working in NST, or she was working in NST, or he was working in health and family welfare. It was the case of the petitioner before this honorable court that they were appointed as a tourist officer by the competent authority, Lordship. If your Lordship may come to page 46, that is the statement of the petitioner. They were silent on the working in different departments, your Lordship.
We have noticed
Yes.
that. That's why we put that question to him also.
Lordship. So your Lordship, see.
But you are the one who has given all those
Yes,
stories.
all those stories.
Why? Why did you bring all those stories?
Because they are trying to manipulate, they're trying to obtain the appointment by fraud. I'll show you, your Lordship. Page 56, your Lordship. My affidavit in opposition to the writ petition. Your Lordship, has your Lordship got it? 56,
56, yes.
para 2. That before rebutting the contentions of the petitioner made in the writ petition, it is necessary to narrate in brief the background leading to the termination of illegal appointment of the petitioner.
Okay,
by
okay. That is how you have explained.
Yes, that is how I explained. The petitioner is the son of the then Director Tourism Department. The petitioner was initially appointed as paramedical worker by such and such dated 24/1/2011 under the establishment of Health and Family Welfare. He submitted his application for the post of tourist officer addressed to the Commissioner and Secretary, Tourism Department on deputation on 4/3/2013, and on the body of the application, the Commissioner and Secretary had endorsed it to the Joint Secretary to put it up on 25/10/2017. Then where is the question of his appointment or temporary on 4/6/2016, Lordship? Because this application was put up on 25/10/2017, your Lordship. Then
Okay, that is why backdate.
yes, backdated, yes. Then I'll show you the backdated file also, your Lordship. Page 57, para 3, Roman 3. Thereafter, no objection certificate from his parent department, that is Directorate of Health and Family Welfare, was forwarded to the Tourism Department on 2/7/2013. 4. While the petitioner is still serving in Health and Family Welfare Department, the petitioner was given appointment as tourist officer +2 gazetted in a Directorate of Tourism on temporary basis, vide order dated 4/6/2016. So his application for deputation was put up on 25/10/2017, whereas backdated was given that 4/6/2016. Thereafter, by order number dated 6/12/2017, his service as tourist officer was regularized. So your Lordship see the manner in which they were manipulating, because the person is the son of the then director, and the other one, VB Zonyo, is the daughter of the Commissioner and Secretary, Lordship. Then para 4, the petitioner was given appointment backdated to 4/6/2016 so as to circumvent the OM dated 6/6/2016 that is banning all appointments on contract basis. All along, the petitioner has been drawing his salary from the Health and Family Welfare Department till 2018. Records prove that the petitioner never joins the Tourism Department, and his name was never shown in the list of the payroll of Gazette Officer of the Tourism Department for the year 2016-17 and March 2018. Having found that the petitioner was illegally appointed as tourist officer in gross violation of the Nagaland Tourism Service Rule 2014 and OM dated 6/6, the service was terminated via order dated 29/1/2019 with immediate effect. So, Lordship, I'll show you, Lordship, page 70. 70 is the pay. payroll of giving it to your lordship till August 2018. My copy is not clear, your lordship, but the name is one. The second last name giving it to your secretary.
Page?
Page 70. Yes, my copy is not visible, your lordship.
Even our copies also.
That's the original copy we could lay our hands on. That's the only copy we could lay our hands on.
What is this?
Lordship, this is the payroll.
Payroll.
Yes, yes. Because in the writ petition, the petitioner is claiming that he was appointed in 2016 and he is serving in the department, so he's not getting his salary, so he should be given his salary. That is what the claim of the petitioner. So we want to show that till August 2018, he was given pay from the NST department, your lordship. Page 70. Then, your lordship, page.
This is annexure 4.
Yes,
Annexure
lordship.
4.
Yes.
Where is the statement in your affidavit?
Affidavit, lordship.
It's in
annexure 4. Lordship, page.
This payroll of which department? Transport?
NST, yes, NST. Page, yes, health and family welfare, your lordship.
Health.
Yes. Page 4.
So this payroll is supposed to show the pay of the petitioner.
Yes, pay of the petitioner, because the petitioner is still working in the health and family welfare department. He was never appointed in the tourism department, no work in the department.
The
lordship.
purpose of annexing this
Yes.
payroll is that to show that
Yes, he never works.
he was working in the health department.
Yes,
not in the tourist department.
No, lordship. Then, lordship.
So that's why your statement at page 59 is the petitioner was listed in the payroll of the Department of Health and Family Welfare during this till 2018. So this is why you have annexed it.
Yes,
correct?
lordship, yes.
Although we cannot read it.
Then, your lordship, page 74. See, this is the file that was put up on 4/12/2017. Your lordship.
Page?
74.
74.
Yes. 74. This is other dated file noting is 4/12/2017. Lordship, the issue of NOC for deputation matter thereof. There are two applicants from two different departments applying for deputation to the Department of Tourism as tourist officer, both having the requisite experiences. And your lordship, number 1 is Bibi Zonyo Tau. Then the number 2 is giving you to your secretary, your lordship. So, your lordship, in this file noting, to issue an NOC that was put up on 4/12/2017, lordship. Then thereafter, the secretary, the commissioner secretary, who is the mother of Vibizonyo Aitao, lordship, in the middle one, she put her signature as 4/6/2016, lordship. This is how they are manipulating the documents. Then in the last para, approved for appointment against the vacancy in question. This is 4/6/2016. This is the signature of the chief minister, the then chief minister. So, your lordship, this is how they are manipulating. So, your lordship, instead of hearing on the writ appeal, it should be dismissed with cause. Even in my writ, before the learned single judge also, I've prayed for an exemplary course, the manner in which they play with the government, your lordship. So this was backdated, your lordship.
What is this page 74?
Page 74.
It is a part of the file.
Yes, that is
Note
the
sheet.
Yes, that is the note sheet for deputation to issue of NOC that was put forward to the authority, your lordship. Because at this point of time, they were never appointed. So if they were never appointed, how could they be given appointment by 4/6/2016 by giving the backdating? Then your lordship may come to page 78. This is also very interesting. This is the letter dated 12 December 2017. The tourism department, they have written to the secretary and PSC for issue of deputation, your lordship. In reference to the subject indicated above, the undersigned is directed to bring to your notice that there are two applicants from two different departments applying for deputation to the Department of Tourism as tourist officer, both having the requisite experience and expertise to work in the department so sought for herein. Their particulars with reference to the places of work and designation may be summarized as below. Number one is Kevin Sekose. Number two is VP Zonyo. Done. Then, hence, you are requested to examine the proposed matter and issue necessary NOC so as to enable the Department of Tourism to consider their entry for deputation, please. So, Your Lordship, this is the letter dated 12 December 2017. Whereas the petitioner were regularized on 6/12/2017. So, Your Lordship, all these are, Lordship, dishonestly cheating, Your Lordship, the government by playing frauds, Your Lordship, by misrepresenting everything, Your Lordship. So, Your Lordship, thereafter, page 79. This is the register. 1, 2, 3, 4, 5, 6. The seventh line from the top. This is the order dated 22/4/2018. The file number is DRSM Establishment 210/2009, DF of Kevin Mutio. So this is the file noting of Kevin Mutio for regularization that was processed in the year 2018.
Where is that from?
1, 2, 3, 4, 5, 6, 7. Seventh line from the top, Your Lordship.
2418.
Yes, 24 2000. Yes, 18. Yes. The file number is TRSM Establishment 210/2009.
What is this
Yes.
to show the movement of file?
Yes, the movement of file for the regularization. So the regularization was moved on 24/2018, whereas they have backdated the regularization as 6/12/2017, Lordship.
Where is the regularization order?
Lordship, Lordship, page 77. Six 12/2017. 77, 6/12/2017. In the interest of public service, the governor of Nagaland is pleased to regularize the temporary appointment of Sri Kivimutu Sekose as tourist officer in the pay band of such and such, with great pay of such and such, plus all other allowances as are admissible under rules from time to time in Nagaland under the establishment of the Directorate of Tourism Nagaland with immediate effect. Srimati Kivimutu Sekose is posted at the Directorate of Tourism till further order. This is issued with the approval of the Honorable Chief Minister of Nagaland, Your Lordship. They could even, Your Lordship, convince the Chief Minister to give bail, Your Lordship. This is how the manner they are playing. So this is in respect of Kivimutu. Then, Your Lordship, in respect of VB Zonyo, Lordship, may kindly turn to page 131. Page 131. Yes. Para 2, that before rebutting the contention of the petitioner made in the writ petition, it is necessary to narrate in brief the background leading to the termination of illegal appointment of the petitioner via order dated 29/1/2019. The petitioner is the daughter of the then Commissioner and Secretary Tourism Department. The then Commissioner and Secretary Department, while holding additional charge as Commissioner and Secretary P&AR Department, issued office memorandum dated 6/6/2016, banning all appointments on contract basis. The petitioner was appointed as LDA cum computer assistant via order dated 3/9/2013 in the establishment of General Manager NST Dimapur, Nagaland. And while the petitioner is still serving as LDA cum computer assistant in the establishment of General Manager NST Dimapur, Nagaland, the petitioner was given appointment as tourist officer class 2 gazetted on temporary basis with a fixed pay of such and such dated 19/9/2017. So, Your Lordship, initially the VB Zonya was appointed as tourist officer temporary on 19/9/2017, Your Lordship. Thereafter, by letter dated 7/5/2018, her service as tourist officer was terminated. Then again, the petitioner was given appointment as tourist officer gazette on temporary basis via 4/6/2016. So all these are backdated in Your Lordship. Thereafter, by order dated 6/12/17, her service as tourist officer was regularized. The petitioner was given appointment backdated to 4/6/2016 so as to circumvent the OM dated 6/6/2016. All along, the petitioner has been growing her salary as LDA cum computer assistant from the Nagaland State Transport Dimapur station till 2018. The petitioner never joined nor served the tourist department, and her name was never shown in the list of the payroll of Gazette Officer of the Tourist Department for the years 2017, and 2018. Having found that the petitioner was illegally appointed as tourist officer in gross violation of the Nagaland Tourism Service Rule 14 and 16, the appointment of the petitioner was terminated by 29/1/2019 with immediate effect. So, Your Lordship, Your Lordship may come to page Lordship. Page 147. This is the petitioner's initial appointment as a tourist officer. 147, dated 19 September 2017. In the interest of public service, the Governor of Nagaland is pleased to appoint Srimati Vibizonyo Undan, daughter of Sri such and such, to the post of tourist officer on temporary basis, plus with effect from the date of joining to the post. Srimati Vibizonyo Undan shall be attached to Institute of Hotel Management, Dimapur, under Directorate of Tourism, Kohima, till further order. So, Your Lordship, when she was initially, while working as tourism, as LDA computer in NST, she was first given as tourist officer by order dated 19 September 2017, Your Lordship.
This is page 147 in your
Yes,
copy?
page 147.
It's 146 here.
Oh. The
Anyway.
146 is the termination of that appointment order.
Correct. So there's some
Paper paging mistake. Your
pagination
Lordship.
is not similar.
Oh, Lordship.
Anyway,
Yes. Then 146 is her appointment as tourist officer was terminated, Your Lordship, by order dated 7th May 2018. Then thereafter, Your Lordship, 148, she applied for tourist officer. So the manner in which she was applying, Your Lordship, tourist officer post is
on the petition.
yes, on the petition. Under the rural development, there is no tourist officer, but she applied for deputation as tourist officer to the Secretary of Urban Rural Development.
When?
148, Your Lordship. This is how the manner they are manipulating the documents, Your Lordship.
No, RD does have. Does
No,
have tourist
no,
officer.
no. It is only under the tourism department. So for our deputation, she applied for tourist officer in the RD. Then the next page is
This
No,
was
but
not applied
see-
by me. This was not applied by me. This is signed by the General Manager of Nagaland State.
No, that's why I was going to ask her.
yes.
See, the petitioner may have applied here and there, but why the general manager Nagaland State Transport also has forwarded
Lordship, see the manner, Your Lordship.
to RD department?
They have override everything, Your Lordship. Forwarding of application of deputation to in respect of Mrs. VB Zonyo NST, Your Lordship. But on the top column, they have made it to tourism officer, all these things. They have cut and they have annexed, Your Lordship. See, the manner in which they are playing, Your Lordship. Then after that, Your Lordship, at page 149, she has applied for deputation on for tourist department, Your Lordship. Prayer for
It is
appointment.
filled up by hand.
Yes, fill up by hand. Everything cut off, fill up, erase, Your Lordship. So, Your Lordship, she applied for tourist.
These are part
officer,
of
Your
your
Lordship.
counter affidavit.
Yes, Your Lordship. The manner in which they are playing the fraud, Your Lordship.
So who else are under the scanner of the vigilance?
Your Lordship, Lordship, right now, I don't know what is the status, Your Lordship.
No, see,
Yes.
from the order itself, it's there.
Yes.
Where is that order? It says 2 officers from the tourism department. No, from the
53, my lord. Page
Huh?
53.
53.
But that does not name anybody.
And then
53.
2 tourist
Yes, yes.
officers and 5
5 tourist assistants.
tourist assistants.
Yes, yes.
So all are in the tourism.
Yes. So, Your Lordship, those tourist officer is a class 2 gazette and tourist assistant is a, Your Lordship,
Non-gazetted?
Yes, non-gazette. So all these persons, they approach before this court, and by common order, Your Lordship, this court has dismissed all the writ petitions, Your Lordship.
No, I was just inquiring about the wider aspect of it,
Okay, Lordship.
leaving aside the present petition as an
Yes.
appellant.
Regarding with
Because
the...
they alone cannot play the
Yes,
entire
yes.
game.
Yes, yes.
There were others also.
So the commissioner...
Parents are also there.
Yes, though they were placed under
So
suspension,
what has
Your
happened
Lordship.
to all those things?
They
My
were
lord, the
placed
charge
under
sheet that has been
suspension,
filed.
Your Lordship.
Huh?
My
RC was
instruct-
filed, then she was placed under suspension,
Who?
Your Lord. The commissioner and secretary.
Gotcha.
Yes, yes. Then after that, I don't know what is the outcome. So
I see.
maybe her pension also has been withheld, maybe, Your Lordship. Yes, yes.
We're not concerned with that, no
Yes,
doubt.
yes,
But
yes.
I just generally just wanted to know what
Yes,
has
yes,
happened.
yes, yes.
Since you've brought out all these things.
Yes,
My lord,
yes,
our
yes.
names were dropped from the charge sheet. These five tourist assistants and tourist officers, when charge sheet was filed by the CBA Vigilance Department, our names were not in the charge sheet. That is what my instruction is.
Okay.
Then, Your Lordship, regarding with the tourist assistant, they have never played fraud, but the appointment was in violation of the service rule. The tourist assistants.
Okay.
Yes. Whereas the tourist officer, in respect of the 2 appellant before this court, they are playing, manipulating everything, Your Lordship.
Where is the RR? RR is available here.
Your Lordship.
Recruitment rules.
Lordship,
There's a mention somewhere
yes,
that
yes.
it's in
I have
violation of the
mentioned.
service rules.
Yes,
My
yes.
lord, the violation is, it should
rule-
be in the copy. I had given it.
Your Lordship, page 58, para 6, Rule 5, clause 2. Page 58, para 6. That with regard to the statement made in paragraph 2 of the writ petition, the deponent respectfully states that the Department of Tourism has a service rule called the Nagaland Tourism Service Rule 2014, wherein the post of tourist officer is class 2 gazette. Rule 5.2 of the Nagaland Tourism Service Rule provides that the post of tourist officer is to be filled up by 25% by direct recruit and 75% by departmental promotion, Your Lordship.
Qualification is what? Hotel management,
7.
Yes, yes.
catering or
59.
tourism related subject or university degree.
Yes, yes.
Yes, my lord. That is
So
7.
both of them, they do
Rule
not have
7. That will
any,
be Rule 7.
any lordship, any qualification. Even if they have also, they cannot be appointed in violation of the service rule, Your Lordship. Yes. Then, Your Lordship, page 153 is the payroll of the,
This is to be through the NPSC, isn't it?
yes, through the NPSC. In view of them appointed as a tourist officer, the tourist assistant who were in line of promotion, they make representation to the government. Then only they came to know, Your Lordship.
I see.
Yes. Page 153. Your Lordship, page 153, third line from the bottom. This is VB Zonyo ITAU LDA. This is the payroll of her pay in August 2018. Third line from bottom, Your Lordship. Then, Your Lordship, page 154, this is the filed noting. This is more clear, Your Lordship. Issue of NOC for deputation matter thereof. So this is number one is in respect of VB Junior. Number two is giving Mutio Sekose. The file was put up on 4/12/17, backdated to 4/6/16, and the CM also backdated to 4/6/16, Lordship. Then the file movement, Your Lordship, for the regularization is at page 157, Your Lordship. This is the NOC for issue of NOC to the NPSC. 157, dated 12 December 2017. Then they could not have been regularized on 6/12/2017. Then 158 is 24/2018. 1, 2, 3, 4, 5, 6, 7. 8 line from the top. This is in respect of Vibizonyo, Your Lordship. 8.
Of page 158.
Yes, yes. 8. And the person above her is Kivingutua. Yes, both these two persons are before this court, Your Lordship.
This was for regularization.
Yes, the regularization was put up in 2018. Then, if at all this is put out in 2018,
No, this shows that there's something was put up.
yes,
But how do we know that this is for the regularization?
Lordship, I have in my affidavit, I have stated 2000.
Which is not disputed.
No, because all these things were manipulated. This is how they were playing, Your Lordship, 2015. Page 136, Your Lordship, I'll read the annex 113. Page 136, para 7. That with regard to the statement made in 3 of the repetition, the deponent respectfully states that the petitioner neither joined nor served the department. The regularization of the petitioner service was done without obtaining PNAR and MPSC clearance, nor the approval of the cabinet, which was contrary to established norms. The matter for PNR clearance was brought to the notice of the government by the Directorate of Vigilance and Anti-Corruption Police, via letter such and such, dated 13/11/2018, and the matter was clarified via letter 25/1/2019, stating that such clearance does not exist. The petitioner contended that her service was regularized by order dated 6/12/2017. However, it is evident from records that the government, by letter dated 12/12/2017, has written a letter requesting the NPSC Commission to examine the issuance of NOC for deputation of the petitioner to the Department of Tourism as tourist officer. As such, it is clearly shown that the regularization of the petitioner's service was done prior to issuance of NSC for deputation. On 2012/2017, the General Manager, NST Dimapur, Nagaland.
Mr. Shukre,
Yes, Lordship.
you're in page 136.
Yes.
Just read the last line. As per,
As per record, regularization in respect of the petitioner was processed on 24/2018.
So this is the
Lordship.
one.
Yes, yes,
So this is the process.
yes.
Which justifies your annexure. There's
So,
no,
Lordship,
there's no dispute to that.
Yes, so when this is processed in 24/2017, how could they be regularized on 6/12/2016? Yes, so Your Lordship, see, the department, we have the service rule. So even if the appellants, they have the requisite qualification, Your Lordship, they cannot be appointed in violation of the service rule. And there is an OEM, Your Lordship, banning appointment on contract basis. And if at all the department they are in need of service, then clearance of the PNR and the NPSC should be obtained, and a person can be appointed on a contract basis as a stopgap arrangement, Your Lordship.
Was it a contract appointment initially?
No, it was a temporary appointment, Your Lordship. And thereafter, it was regularized. So everything is made in violation of the service rules. And Lordship, I have shown before Your Lordship that the manner in which they are playing, Your Lordship, this requires, Your Lordship, no show cause notices to them. So what the learned single judge has rightly said that even an opportunity of being heard is given to them, it is a futility exercise, Your Lordship. And Your Lordship, they are playing fraud, and the initial appointment is void, as Your Lordship has already pointed out. It is void and illegal. So where is the question of affording them an opportunity of hearing? They are not an employee. They are not covered under Article 311 of the Constitution also, Your Lordship. So, Your Lordship, my prayer is that they have lost in the writ petition, but yet again they're approaching this court, Your Lordship, trying to, Lordship, manipulate this court, uh, to abuse the process of this court. Before the learned single judge also, Your Lordship, I pray for an exemplary course. So in this appeal also, Your Lordship, I pray that the appeal should be dismissed with an exemplary course, Your Lordship. And even for the citation, Your Lordship, regarding that, when the appointment is illegal, Your Lordship, the termination is justified and without no show cause notice is necessary. Lordship, 2019 16 SCC 782. Para 5, 6, 7, 8, and 9, Your Lordship. Lordship, I just said 2018 or 2019. It's 2019.
19.
Okay, 2019.
19, volume
Yes,
16.
yes. Lordship, Lordship, para 5. Para 5. We have
Yes.
page 787. We have carefully perused the pleadings and the written submission made by the parties, and also considered the submission made at the oral hearing. In the present case, the respondent had sought to secure regularization of his services, even though he did not fulfill the prerequisite of a minimum of 3 years of continuous service prior to 22/1/2001, as per the revised policy of the government of Punjab for regularization of work charge, daily wage, and other similar categories of employees. The respondent had failed to produce any evidence whatsoever to support his claim for regularization. The respondent had sought to have his name included in the final list recommended for regularization by colluding with certain officials of the appellate authority who had interpolated his name in the final list forwarded to the authority. Then, Lordship, I will come to 5.5. It is well settled that an order of regularization obtained by misrepresenting facts or by playing a fraud upon the competent authority cannot be sustained in the eye of the law. In Rajasthan Tourism Development Corporation Limited versus Intijam Ali Zafar, it was held that if the initial appointment itself is void, then the provision of the Industrial Dispute Act 1947 are not applicable for terminating the services of such workmen. In a similar case, this court in such and such held that since the respondent had obtained his appointment by playing fraud, he could not be allowed to get the benefit thereof. 6. In the present case, the single judge had held that, rightly or wrongly, the respondent had obtained regularization and was therefore entitled to a disciplinary inquiry. The division bench affirmed the judgment of the single judge. The 6.1, the High Court, however, failed to appreciate that the decision in ECIL is applicable to employees of government department. Since the very appointment of the respondent on regular basis was illegal, he could not be treated as an employee of the appellate authority. In such and such, this court held that service rendered in pursuance of an illegal appointment or promotion cannot be equated to service rendered in pursuance of a valid and lawful appointment or promotion. 6.2, the illegality of such an appointment goes to the root of the respondent absorption as a regular employee. The respondent could not be considered to be an employee and would not be entitled to any benefit under the regulations applicable to employees of the appellant authority. Therefore, the High Court erroneously placed reliance on the decision in ECIL, which would not be applicable to the facts of the present case. Para 7, the question of holding disciplinary proceeding as envisaged under Article 311 of the Constitution or any other disciplinary rules did not arise in the present case, since the respondent was admittedly not an employee of the appellate authority and did not hold a civil post under the state government. He was merely a daily wager on the master rolls of the appellate authority. 8. It is abundantly clear from the facts of this case and the material on record that the regularization of the services of the respondent was illegal and invalid. The respondent was provided a full opportunity to educe evidences to establish that he has served 3 years continuous service prior to such and such. However, he failed to furnish any proof whatsoever to substantiate his claim. In light of the aforesaid discussion, the present appeal is allowed and the order dated passed by the division bench of the Punjab and Haryana High Court is set aside. The appointment of the respondent on regular basis was invalid since the respondent did not have the prerequisite experience of 3 years continuous service prior to 22/1/2021. The respondent has sought to secure regularization on the basis of interpolation in the final list of employees recommended for regularization. Such an appointment would be illegal and void ab initio and cannot be sustained. The appellant authority rightly terminated the respondent void order dated 22/5/2003. Then, Your Lordship, regarding on the issue of natural justice, 2018-15 ACC 463.
463.
Yes, yes. Para 1, 23, 24, 25, and 31.
Para 123.
1, 23, 24, 25, and 31. Your Lordship, the para 1.
Just a minute.
Yes. Has Your Lordship got para 1? Page?
466.
Yes, 466, yes.
Yes.
The central question posed in this appeal are whether the appointment of the respondent to the post of veterinary compounder made by the director in charge at the relevant point of time without approval of the competent authority was a nullity or a mere irregularity, which could be glozed over by the department to avert disruption of his services. And number 2, in any case, whether his services could be disrupted without giving him an opportunity of hearing. The Lordship may come to para 23. Page 475. Yes, para 23. In the state of Manipur, the appointment letters were cancelled on the ground that the same were issued without the knowledge of the Department of the State. The court, after adverting to the reported decision, concluded that the candidates were not entitled to hold the post, and in a case of such nature, principle of natural justice were not required to be complied with, particularly when the same would result in futility. It may be useful to advert to para 22 of the reported decision, which read thus. My learned friend is harping on this issue, Lordship, para 22. The respondent, therefore, in our opinion, were not entitled to hold the post. In a case of this nature, where the facts are admitted, the principles of natural justice were not required to be complied with, particularly when the same would result in futility. It is true that where appointment had been made by a competent authority, or at least some steps has been taken in that behalf, the principle of natural justice are required to be complied with in view of the decision of this court in Muragave Udayar. Whereas in our case, it is obtained by fraud. So, Your Lordship, there is no requirement of natural justice. Para 24, in para 30 of the reported decision, the court adverted to the exposition in MC Mehta vs. Union of India, which evolved the useless formality theory. It is opposite to reproduce para 30 to 32 of the reported judgment, which read thus, case. In MC Mehta vs. Union of India, this court developed the useless formality, Your Lordship, theory stating, then Lordship, para 22, 13 line from the top. 13 line from the top, the line, thus in relation to cases. 13 line from the top. Yes, yes. Thus, in relation to cases other than those relating to admitted or indisputable facts, there is a considerable divergence of opinion whether the applicant can be compelled to prove that the outcome will be in his favor, or he has to prove a case of substance, or if he can prove a real likelihood of success, or if he is entitled to relief, even if there is some remote chance of success. We may, however, point out that even in cases where the facts are not at all admitted or beyond disputes, there is a considerable unanimity that the court can, in exercise of the discretion, refuse certiorari, prohibition, mandamus, or injunction, even though natural justice is not followed. We may also state that there is yet another line of cases, as in State Bank of Patiala versus S.K. Sharma, Rajendra Singh versus State of MP, that even in relation to statutory provisions requiring notice, a distinction is to be made between cases where the provision is intended for individual benefit and where a provision is intended to protect public interest. In the former case, it can be waived, while in the case of the latter, it cannot be waived. In Kendriya Vidyalaya Sangatham, it was held, it is clear that if after the termination of services of the Sikh Dr. K.C. Rakesh, the orders of appointment are issued, such orders are not valid. If such appointment orders are a nullity, the question of observance of principle of natural justice would not arise. In Bar Council of India versus High Court of Kerala, it was stated that principle of natural justice, however, cannot be stretched too far. Their application may be subject to the provision of a statute or statutory rules. In the present case, the appointment letter was admittedly issued without the approval of the competent authority. 25. In Dhirendra Singh v. State of Haryana, termination of the appellant in albeit without notice was not interfered with by the court, as admittedly the same was not approved by the competent authority. The underlying principle will apply proprio vigor to the present case, as the letter of the appointment has been issued by an officer who had no authority to do so, and also because it was issued without waiting for the approval of the competent authority. Resultantly, there was no necessity to afford opportunity to the respondent before issuing the letter of cancellation of such appointment. The mere fact that such letter of appointment had been issued in favor of the respondent does not bestow any right in his favor, much less to insist for an opportunity of being heard. Then para 31, Your Lordship. We have no hesitation in concluding that in the fact situation of the present case, giving opportunity of hearing to the respondent before issuance of the subject of his order was not an essential requirement, and it would be an exercise in futility for the view that we have taken the exposition in D.K. Yadav, which, commended to the High Court, in our opinion, has no application to the fact situation of the present case concerning an appointment which is void ab initio and nullity. So, Your Lordship, right now also, even if we give an opportunity to them, what more ground they could produce. So it is only useless formality, Your Lordship. So my prayer is that, Your Lordship, the appeal may be dismissed with cause, Your Lordship. That's my prayer.
My lord, facts, I will not say anything. Only one observation. That process that was shown, that allegation that we have managed even the chief minister of the state, where is the pleading to that? Page 74 that has said, even the chief minister's signature was backdated. It is just said that the personal principal secretary was not, it was not, did not go to the principal secretary. That was the pleading. Parliamentary secretary.
Your Lordship, at page 60, everything, Your Lordship, the parliamentary secretary,
Yes.
the then chief minister approved for appointment against the vacancy in question, backdated to 4/6/2016. Page
So it is the
60.
chief minister who has backdated it.
The chief minister.
If your lordship comes to page 60, application for NOC, issue of NOC for deputation was processed on 4/12/17. The commissioner secretary appended signature, backdated and endorsed directly to chief minister, bypassing the then parliamentary secretary.
Then
The
the-
then chief minister approved the appointment against the vacancy in question, backdated 4/6/2016.
Yes.
This is their pleading.
We'll examine and pass appropriate orders.
Just as of natural justice, my lord, much things have been said. I would just rely on this, on natural justice, para 9, 1998, 8 SCC 194.
Please repeat,
1998, 8 SCC 194. I have supplied a copy. Para 9. Para 9. The law is settled that non-arbitrariness is an essential facet of Article 14, pervading the entire realm of state action governed by Article 14. It has come to be established as a further corollary that the audi alteram partem facet of natural justice, also requirement of Article 14 for natural justice, is an antithesis of arbitrariness. In the sphere of public employment, it is well settled that any action taken by the employer against an employee must be fair, just, and reasonable, which are components of fair treatment. The conferment of absolute power to terminate the services of an employee is an antithesis to fair, just, and reasonable treatment. This aspect was exhaustively considered by a constitution bench of the court in Delhi Transport Corporation versus DTC Mazdoor Congress. My thing is, why an opportunity ought to have been given? Really, this one, read with the fact that of the judgment relied on by the single court and my learned friend at para 22 of para 22 of the 2007 judgment, when an appointment, it is true that where appointments have been made by a competent authority, it does not say about appointment is made by fraud, appointment is made taken with some undue influence. It is not the realm of the judgment. That judgment says it is true that where appointments have been made by a competent authority, or at least some steps have been taken in that behalf, the principle of natural justice are required to be complied with. In this case, what has happened? The department did not even know that appointments were given. Mandal commission, some mandal, some mazdoors were given. Departments did not know. High Court has said, no, their opportunity has to be given. Yes, ultimately their petition was not allowed. But the ratio is, had to be, if it is a competent authority who has given the appointment, you have to give him an opportunity. They are not saying that my appointment letter was not given by a competent authority.
I'm saying your appointment is obtained by fraud.
Yes, this judgment does not say about fraud. They have not alleged fraud.
All right.
Action speaks louder than voice.
I leave it to your lordships.
Heard Mr.
D.K. Bhattacharya.
D.K. Bhattacharya, learned counsel for the appellants, and Ms. V. Shukre, learned additional advocate general, Nagaland, for the state respondents. Hearing is concluded. Judgment reserved. Get this printout. There are some matters for the second half. Okay. I'll just leave it here.
May I please, the Lordship? Lordship, I beg to mention item number 7, Lordship. Lordship, I have taken the consent of the opposite party, Lordship. Lordship, I pray that this matter come after a week, Lordship.
Oh,
Item 7.
you are in a hurry.
Lordship, I have taken the consent of the
Who is the other side?
HK Sabil, Lordship. I have taken the consent, Lordship.
So, yes.
Lordship, let it come after a week, Lordship.
Can I share with you one thing which I discovered?
Lordship.
Recast petition was filed in this matter,
Lordship.
but was there any application for amendment? I do not find any miscase.
No. No.
Simply that recast petition has arrived is available in the file
Lordship.
because it was heard by a single judge.
Lordship. Lordship.
And after the recast, it came over to the division bench.
Lordship.
So I was just examining this aspect. I could not find any miscase.
Lordship.
You just look into that.
Yes, Lordship.
How much time you require?
Uh,
You want some time?
Lordship.
When?
A week's time, Lordship.
As paid for by learned government advocate, Mr.
Vijmon.
V. Zimomi,
Lordship.
and not objected to by the opposite party. Matter stands adjourned for a week.
Then let it come after 2 weeks, Lordship. 2 weeks, Lordship.
Okay, after 2 weeks.
Hello, Bless.
Rest will come back.
For admission, item number 8 and 9.
May it please, my lord. This is an appeal against conviction, my lord, by which the appellant has been convicted under section 376 and 302 of the Indian Penal Code, my lord, by order dated 1/10/2004. Now, my lord, since his initial arrest, the appellant is in custody, my lord, till date. He was arrested on 18/5/2003, my lord. Now, my lord, the IA, I have filed praying for a delay condonation of my lord 6,063 days, my lord. My lord, the appellant was unaware of his rights to prefer an appeal before this honorable court, and it was only through the action of some good-spirited paralegal volunteers of the Legal Services Authority that he became aware of his rights to approach this honorable court, my lord. Earlier, he approached by filing
He is locked in which jail?
district jail pact, my lord.
Heck,
My lord.
it is not visited by the paralegal volunteers.
It is being visited. So in 2019, my lord, he was made aware that, my lord, by the paralegal volunteers.
2019.
19. Yes, my lord. And then before the single bench, my lord, he has preferred writ petition 2 of 2019, under which he prayed for releasing, for premature release, my lord. Before the state government, a representation was made, my lord. The government did not consider it.
What has happened to that?
That a direction was given, my lord, and for disposal of his representation within 5 months. However, my lord, the state government refused to consider his case on the ground that under section 4.1 of the notification
Which
issued by the
notification?
government of Nagaland, my lord.
Yes.
Offenses relating to 376, 395, Takuiti, my lord, this cannot be considered for premature release. So since he was convicted under 376, my lord.
376.
Yes, my lord. His case was not considered. 4.1, my lord. The next page. Otherwise, my lord, 2 other persons also made similar representations, and those 2 people also, my lord, approached this on the single bench, my lord. And similar directions were given in other case, my lord. Those 2 persons were considered under that notification because in that 376 was not involved. Here he was not considered because 376 is involved, my lord. Now in the criminal appeal, my lord, I have made a specific ground that substantial law has been misinterpreted. In the sense, my lord, 376 can happen before 302, but 376 cannot happen after 302.
It is 302 also is involved.
Yes, 302 is involved, my lord.
376 and 302.
Yes, my lord. Now he could not have been convicted under 376, my lord.
Why not?
Because, my lord, only after death of the victim, my lord, the intercourse happened. It is categorically.
As per the evidence.
Yes, as per the evidence and then as per the judgment, my lord.
Okay.
Evidence, my lord, there is also some difficulty, my lord, with regard to LCRs, my lord. We have approached, but it appears, my lord, there was shifting of court premises from one building to the other, in fact. And then during that time,
Conviction was by the ADC.
ADC judicial, my lord. That is, presently, it has been redesignated as district and sessions judge, my lord.
ADC means additional.
Yes, my lord. Additional
not
Deputy
assistant.
Commissioner Judicial.
Not assistant, additional.
Additional, my lord. Additional Deputy Commissioner Judicial, my lord. So, my lord, in the criminal appeal, my lord.
You are Mr. Sentianga.
My lord.
You have said so many things. Firstly, the delay part is there. Secondly, the merit of the appeal. Thirdly, the premature release.
My lord.
All these things cannot be considered at one go. No?
Yes, my lord. Yes.
You have to first overcome the hurdle of limitation.
Yes, my lord. My lord.
Then we'll see whether the appeal has merit.
Yes, my lord.
Then
I
examine.
I just wanted to point out the ground that I have taken, my lord, in the appeal, just in order to show that, my lord, grave miscarriage may result if
And that
the IA is not allowed.
that particular writ petition wherein the court said that it may be disposed of has not been disposed.
That has
Premature
been-
release
Yes, that has been disposed.
has been disposed.
Yes, and he was not considered because of the presence of 4.1 after notification.
No, considered means it can be rejected also.
Yes, he was
To be
rejected.
given or to be rejected means considered
Yes, my
in
lord.
any way.
Yes, my
So
lord.
it was considered and rejected because
Yes, my lord.
4.1 provides that those
Yes, my
people
lord.
who are convicted for
My lord,
rape
my lord. That is exactly what
cannot
happened.
be. So that was by an order.
Yes.
An order was passed, isn't
Yes,
it?
lordship, lordship, lordship. Now,
Yes.
my lord, if I may allowed to place a single judgment, my lord. I have submitted the book list this morning, my lord.
Single judgment.
Yes. In the IA, my
Why
lord.
not 2, 3 judgments? Why only single judgment? Yes, what is this? On
Lord-
delay?
Yes, my lord, on delay, my lord. 2011, for para 3, my lord. 14 SCC 465, para 3. I may be allowed to read it, my lord.
Please read.
We must, however, add that in cases of conviction and imposition of sentence of imprisonment, the court must show far greater indulgence and flexibility in applying the law of limitation than in any other kind of case. A sentence of imprisonment relates to a person's right to personal liberty, which is one of the most important rights available to an individual, and therefore the court should be very reluctant to shut out a consideration of the case on merits, on grounds of limitation, or any other similar technicality.
What are the facts in this case?
The facts in this case, my lord, is that, my lord,
Delay of 15 months.
I believe so, my lord. Yes.
And what was the appeal filed? It was a revision filed. Criminal revision.
Yes.
What is the
However, the principle, my lord.
what is the period of limitation for revision? 60 days.
60 days, I believe, my
60
lord.
days.
Yes.
So here revision was filed after 15 months. That's why it was rejected. But the High Court, the Supreme Court has said that in paragraph 3, which you just read out.
Yes. But the principle, my lord, laid down by the Honorable Supreme Court,
Correct, correct.
Yes, yes.
But on your own, what have you done? What explanation have you tendered?
That,
Let us see.
yes, at paragraph 4, that the applicant, appellant, my lord, he was unaware of his rights.
Delay is IA
IA 22 of 2022, my lord.
Yes, 22.
I have explained the delay in paragraph 4. That I may be allowed to read it.
Just a minute. Page 3.
Page 3, yes, page 3.
Please read.
That the applicant was unaware of his legal rights until he was informed by some good-spirited legal volunteers from the Nagaland State Legal Services Authority about his right to approach this honorable court. Therefore, on 3/7/2019, the applicant filed WP Criminal number 2 K 2019 before this honorable court, which was disposed by order dated 4/7/2019 with a direction to consider the applicant's representation for premature release within 5 months. Thereafter, on 9/3/2021, the applicant filed criminal original contempt petition number so and so before this honorable court, which was disposed by order dated 24/8/2022. Thereafter, The present council began to make correspondence with the Nagaland State Legal Services Authority, research and draft the present appeal. The detailed breakup of the delay is given in the table below for your lordship's ready reference.
So you start the sentence with saying that you were unaware.
Yes, lordship. He is a person living in the village, my lord, with little education. And from the facts that is narrated in the case, we can also make out that, my lord, perhaps, my lord, he was also suffering from some mental disturbance.
You are appearing as a
Legal Service Council, my lord.
Legal Service Council.
My lord.
And what about this order by which he was convicted?
Yes.
Don't you have a more legible copy?
I have annexed a type copy also. The type copy begins from page 15.
Okay, type copies here.
Yes,
I
lordship.
see. Yes, what do you say?
May I please, my lord. Lordship, to believe that the appellant was unaware of his rights is unbelievable because he was represented by an advocate when the trial was conducted. The
An
others-
advocate appointed by the court, lordship, and amicus, not his own
He's-
private
he
counsel.
He was represented
Let
by
him
an
submit.
advocate. Now he pleaded guilty, and the judgment was passed.
He pleaded guilty.
Yes, and he has chosen that. He has, by virtue of the fact that he was guided by the advocate, he knows that he has, if he wanted, he had option of appealing before the higher judiciary, but he has given up that lordship. Only after 14 years, he filed representation for premature release, and only after that he's coming before this court. So lordship, to allow this type of petition, it will open the floodgate. It become indefensible, lordship.
Let us see where has he admitted.
Lordship, 235 on quantum of sentence. 235 subclause 2 was also not followed.
No, we are on the admission part now.
Yes.
Let us not rush into everything. Okay.
Yes,
We'll go
lordship.
step by step. Now, where in the judgment?
In the first portion, in the first page itself. In the fourth paragraph, the content of charge has been read over and explained to the accused, to which the accused pleaded guilty. First page of the judgment, lordship.
Then, despite pleading guilty, trial went on.
Yes.
So there are two things. One is that he pleaded guilty.
Yes, lordship.
But nevertheless, the trial court
Yes.
has gone into the evidence.
Yes, lordship.
And on these 2 counts, we found him guilty.
Yes, Lordship. However,
Yes, so we intend to condone the delay and will examine the appeal on its own merit.
my lord.
It so happens that people file appeal from jail through the special superintendent or superintendent jail.
Yes.
Comes to the court in a piece of paper. We treat it as an appeal and we don't look into the delay part. It is admitted straight away. So out here it may be a number of days, but still he has to have a chance of to be heard again. We may dismiss the appeal ultimately, we don't know, but at least he has to be heard. Heard Mr. Senti Younger. Legal Aid Counsel,
Yes, my lord.
Learned Legal Aid Counsel for the applicant, and Mr.
Kiangami, Lordship.
K. Angami, Learned Public Prosecutor,
Lordship.
Nagaland, for the state. Next para, by filing this application, the applicant prays for condoning delay of 6063 days in filing the connected appeal preferred against the judgment and order dated 1/10/2004, passed by the Additional Deputy Commissioner, within bracket Judicial, Heck, Nagaland, in GR number 27 of 2003. Stop. Referring to the application, the Learned Counsel submits that the applicant was unaware about the fact that he can file an appeal before the High Court. And since his arrest on 18/5/2003, he is in prison. To stop. Only when some paralegal volunteers from the Nagaland State Legal Services Authority visited the jail that he became aware that he could file an appeal. Not could, he can file an appeal. He can file an appeal before the High Court. To stop, the applicant initially approached this court by filing WP criminal number 2K of 2019, praying for premature release. Stop. The writ petition was disposed of by order dated 4/7/2019 by directing the state respondents to consider the application filed by the applicant for premature release within a specified time frame of 5 months. Stop. Although his application was initially not considered, but subsequently the same was rejected in view of the provisions contained in clause
4.1, my lord.
4.1 of the notification dated 16/5/2001. Is it 2001 or 4? Hmm, 2001. Issued by the Home Department, Home Branch, Government of Nagaland. Stop. In other words, as per the said provision, persons who are convicted for offences such as rape, dacoity, terrorist crimes, etc., are not eligible for premature release from the prison. To stop, the applicant thereafter filed the instant the said application by availing the services of the legal aid counsel given by the Nagaland State Legal Service Authority. Stop. The learned counsel therefore submits that the delay in filing the connected appeal may be condoned, so that the appeal of the applicant can be examined on merits. Next para. Mr. K. Angami, learned public prosecutor, on the other hand, submits that a bare perusal of the impugned judgment and order reveals that the applicant was convicted on his plea of guilt, and therefore no purpose would be served if the delay is condoned. Stop. He also submits that the applicant was duly represented by a lawyer appointed by the court, and therefore it is most unbelievable that he is ignorant about the provision for filing an appeal. Stop. Under the circumstance, he submits that the delay in filing the appeal may not be condoned. Stop. Next para. We have heard the submissions made by the learned counsels for the rival parties, and we have also perused the materials available on record. The applicant has taken the plea of ignorance about the provision for filing an appeal before the High Court. Stop. He has also stated that he has come to learn about the provision for filing an appeal only after being visited by paralegal volunteers of the Nagaland State Legal Services Authority. Stop. We have no reason to disbelieve the contention of the applicant. Stop. In fact, the apex court in the case of Abdul Ghafoor and another versus State of Bihar, 2011, 14 SCC 465, which is relied upon by the learned counsel for the applicant. At paragraph number 3 of the judgment has observed and held as follows. Please abstract this, okay? Page 466, paragraph 3. Next para. Coming back to the present case, it may be seen that the applicant has been convicted for life and he has been in imprisonment and he has been imprisoned since 18/5/2003. That is the date of his arrest. And therefore, the appeal filed by him deserves to be examined on merits. Stop. We also notice that although the applicant had pleaded guilty, but the learned trial court proceeded to examine the case of the prosecution before convicting the applicant. Full stop. Next para. In view of above, we are of the considered view that the applicant has made out a case for condoning the delay. Stop. Accordingly, the delay of 6063 days in filing the connected appeal stands condoned. IA is disposed of.
Right, my lord.
Now, what to do with the appeal?
My lord, if the LCRs can be called, my lord.
That will be called only after it is admitted.
My lord.
We admit it and we call the records. What is there? Every single day is precious.
My lord.
If you are behind four doors, four walls. But this bail application will have to issue notice only. We cannot do anything beyond that.
Yes, lordship.
And I don't know why it was recorded as bail application, registered as bail application. Is it like that? Because this is an application under 389.
Yes, lordship.
And I find that normally it is registered as criminal misapplication. Next, you write in the main appeal. In view of The order passed today in IA Criminal number 22 of 2022. The appeal is taken up for admission. Heard next paragraph, heard Mr. Senti Younger, learned counsel, legal aid counsel, appearing for the appellant, who submits that by filing this appeal, the appellant has challenged the judgment and order dated 1/10/2004, passed by the learned Additional Deputy Commissioner, within bracket judicial, Hague, Nagaland, in GR 27 of 2003, in connection with Hague PS case number 0012/03, by which the appellant was convicted under section 302 and 376 of the Indian Penal Code and sentenced to undergo imprisonment for life. Next para, let the appeal be admitted. Call for the LCR. And issue notice to the state, Mr.
K. Angami, Your Lordship.
K. Angami, learned public prosecutor, accepts notice on behalf of the state. Requisite copies of the memo of appeal be furnished to him, if not already done. List the matter again on receipt of the LCR.
My lord, I have been informed, my lord, that the LCR is missing, my lord. Which is why, my lord, and then even this impugned judgment, we obtained it from the jail authorities, not from the court. The jailer, the superintendent, he keeps a copy of every judgment and order of the inmates lodging within the jail, and that is how we obtained the impugned judgment and order.
At this stage, we have been informed by the learned legal aid counsel that the LCR is not to be found. However, as we have requisitioned the LCR, the competent authority concerned shall inform the court,
my lord,
about the status of the LCR. If the LCR indeed is not available,
my lord,
let it be certified, then we'll see what to do.
my lord, my lord,
This is your own information.
my lord, my lord,
We want information from the authority.
my lord.
And what is this? What is the writ petition?
Yes. In order to show the notification,
you can give me
lordship.
that.
Yes.
Okay. Then in the IA, this bail application, you write? Heard Mr. Senti Younger, learned legal aid counsel, who submits that the applicant, by filing this application under section 389 within bracket 2 of the CRPC, prays for suspension of the sentence. Prays for the suspension of the judgment and order dated 1/10/2004 and the sentence imposed by the learned Additional Deputy Commissioner, Judicial, Hague, Nagaland, in GR 27 of 2003, in connection with Hague PS case number 0012/2003, by which the applicant was convicted under section 302 and 376 IPC and sentenced to undergo imprisonment for life. Next para, issue notice to the state, returnable by 2 weeks. Mr. K. Angami,
Lordship, this also be taken up along with the main writ petition, Lordship. The main appeal, Lordship.
okay. Issue notice not returnable, huh? Issue notice, Mr. N. Angami,
Angami.
K. Angami, learned public prosecutor, accepts notice on behalf of the state. Requisite extra copy of the application be furnished to him, if not already done. the state will be entitled to file any objection, to the application if so advised. The matter will be listed along with the criminal appeal. Matter will be listed again along with the criminal appeal, main criminal appeal. Stop. The registry shall also examine as to whether the instant application being made under section 389 CRPC should be registered as a bail application or as a criminal misapplication or IA criminal. Is there any IA criminal?
Yes, Lordship, IA criminal is there.
Yes. And put up a note. Yes.
Deeply obliged.
For admission, item number 11.
Nothing. You give this book also, huh? This will be required as to abstract.
My lords,
Yes.
I'm appearing for some of the private respondents in this matter. Actually, I believe there are 72 private respondents, and out of 72, I'm representing 47 of the private respondents, my lord. I have a list of the private respondents I'm representing, so I'll just...
This is item 11.
My lord.
But as per the cost list, there are
my
only 22 petitioners, 4 respondents.
My lord, records will show that by order date 24/8/2022, this honorable court had impleted the private respondents.
Oh. So this should have been reflected somewhere. Order dated?
24/8/22, my lord.
IA 136. Where is IA?
IA 135, my lord, 135 of 2022.
No, but the order reflects 136. Or some typing mistake here.
Linked case, my lord, 123 of 2022.
120.
No, there's an IA. IA 135 of 2022. There are 2 orders to this effect, okay? Yeah, they did not. See, 2/8, nah? 2/8 also, and order dated 2/8/2022 in IA 121 of 2022, my lord. That order also may be relevant in this regard.
What is that IA for?
This IA is for impletement of the private respondents, my lord.
So how many applications are filed for impletement? Even 135 is also implement.
My lord, I'm for the private respondent. Petition is...
One 135 is for implement. Then what is 121 for? This is for stay. Oh, this is 123. No, WPC. IA 121. This is for stay. Is there any stay order?
Yes, my lord, there is it.
We direct the respondents not to declare the results of the interview as far as the Hindi graduate teachers post is concerned.
My lord.
Teachers' disposal of the writ petitions. So there's a stay already.
My lord.
So 131 is closed, I think. I mean 121. Then 135 is for impleadment. Now impleadment was allowed, but has it been corrected in the cost title?
Yes, Lordship. We have implemented all the private respondents.
Where? Oh, yes, it is here. But the CIS has not been updated. That's why. That is where the confusion lies. How many respondents are there in all? 76.
Yes, Lordship. Private respondents 5 to 76. Government respondents 1 to 4.
You represent which respondent?
Shall I furnish this list, my lord? I'm representing 47 of them, and I have a list here. Since it's not in sequence, we're allowed to furnish this.
Yes. Then what about the others? You've taken steps?
Lordship, we have served substitute notice. We have,
By newspaper publication?
Yes.
And where is the newspaper publication? This is the list.
My lord, yes.
Altogether 47. But the court has already deemed served the notice as per the last court's order,
Yes, Lordship.
isn't it? So what is to be done now? Why is it listed today?
My lord,
Ah.
I have a prayer. I beseech my lords to kindly grant me 2 weeks' time to file an affidavit on behalf of the private respondents who I represent.
Affidavit in opposition.
My lord.
Of course, that is your right to file your response to the writ petition.
My lord.
You're taking time for the first time.
Yes, my lord.
You're appearing for the first time also.
Yes, my lord. I filed my affidavit only on the 17th. That was last week, my lord.
What is your good name, please?
Bakaladam.
Your name?
Alezo Kire. ALEZO.
Please write down by order dated 1/3/2023. Notice was declared to be complete upon all the respondents, comma, including the private respondents. Stop. Today, Mr.
Alezo. ALEZO, my lord. Alezo Kire.
Alizo.
Shall I write it down?
Yeah, write and give. Alizo Kire, learned counsel, submits that he has instructions to appear on behalf of the private respondent numbers 5 to 15, comma, 17, comma, 19, comma, 21, comma, 25, comma, 26, comma, 28, comma, 29, comma, 31, 32, 37, 39, 41 to 45, comma, 48, comma, 51 to 53, comma, 55 to 58, comma, 61 to 66, comma, 68 to 71, 73 and 74. Within bracket, 47 numbers in all. Full stop. He also submits that he may be given 2 weeks' time to file affidavit in opposition. Full stop. The prayer is allowed. List the matter again after 2 weeks. Respondents to file their affidavit in opposition in the meantime. You may check up the numbers if you want this year.
I'm obliged, sir.
Item number 14.
What is this? State appeal?
Yes, Lordship. There is a delay of 233 days.
No, 223 days.
223 days, Your Lordship. Yes. And Your Lordship, the delay, the reasons why delay was occurred, I have mentioned at para 3, page.
Is it listed for the first time today or
No, on the earlier occasion.
you have filed your objection?
No, Your Lordship, I have no objection.
Oh.
I have no objection to the continuation of delay. I would rather the matter be taken up and disposed of.
Yes. Which is the IA concerned? This IA 8. Is it IA 8?
IA 8.
Okay. What are the reasons you have given here?
Lordship, at page 4. Page 4, this judgment order was passed during the.
There's one famous case from Nagaland.
Yes.
Lipopao.
Yes,
Supreme
Lord.
Court.
Yes, Lordship. But today I didn't have that judgment. Yes. So, Lordship. But this judgment was passed during the high surge of COVID. And after the judgment was passed, different communication with the departments, the finance, the government, as well as the.
All right.
Yes, Lordship.
I heard Ms. V. Shukri, learned additional advocate general for the applicants, and Mr.
Tongpok Pongener, Your Lordship.
Tongpok Pongener.
Yes, Your Lordship.
Your name is not there, no? The boss list. Oh, Tongpok Pongener, learned counsel for the respondents.
Respondent only.
Oh, respondent.
Sole respondent.
Respondent?
Yes, Your Lordship, I am the sole respondent.
No, it says.
Respondent number 1.
And another.
Yes. Respondent number 1, Lordship.
Respondents.
Oh, Your Lordship,
Yes.
the accountant general, yes, Your Lordship.
Opposite number 1.
Oh.
Number 2 is
The pro forma.
Respondent number 1.
Yes, respondent number 1.
Respondent number 1. Stop. By filing this application, the applicants seek condonation of 2 to 3 days delay in filing the connected writ appeal. Stop. Ms. V. Shukre, learned additional AG, submits that the delay in filing the writ appeal was on account of high surge of COVID-19 pandemic during the relevant time, and for which there were frequent lockdowns imposed by the government. Stop. She also submits that since interdepartmental consultation was required before deciding to file an appeal, the same took some time, and hence the delay. Stop. She therefore submits that the delay in filing the connected writ appeal may be condoned. Next para, Mr. Tongpok Pongener, learned counsel for respondent number 1, submits that he has no objection to the delay he has no objection if the delay is condoned, and submits that the appeal may be heard on merits. Next para, considering the submissions made by the learned counsel for the rival parties, and upon perusing the statements made in the interlocutory application, the delay of 223 days in filing the connected writ appeal stands condoned. I is disposed of accordingly.
Lordship, IA 9, I have a prayer for stay. Lordship, here, what happened, the petitioner, he was appointed as a graduate teacher on ad hoc basis on 16/4/1990. Then thereafter, he was regularized in service on 14/5/2001. So the state government, we have introduced the SCP scheme in 2002. So that SCP scheme do not cover the graduate teachers because they are getting higher salary. Then only in 2008, the SCP scheme was made effective to the graduate teachers. So accordingly, the petitioner was given the first SCP with effect from 21 to 2008. Lordship. But however, the learned single judge, he calculated his date of ad hoc basis as the regular appointment, and he counted the ad hoc basis for the payment of SCP. And the learned single judge also has directed the accountant general to pay the SCP to the petitioner, whereas it is the state who has to pay. So for that reason, we are filing an appeal. So, Your Lordship, there is a perversity in that order, Your Lordship. And there are 2 writ petitions still pending, Your Lordship, before this learned single judge. So, Lordship, I pray that this stay may be granted, Your Lordship.
2 writ petitions means
Yes, Lordship,
on
this,
similar issue.
No, Your Lordship, in the same case.
Lordship,
This honorable the learned
yeah,
single.
consequent to this judgment, Your
Yes.
Lordship, the petitioner has again filed 2 writ petition, Lordship, pending. Because
For what?
for what? Because Lordship, as per the calculation of the department, the petitioner is supposed to get the second MSCP in 2018. So after the disposal of this writ petition, we have granted the second SCP to the petitioner with effect from 2018. He challenged that writ petition by way of a writ petition. And when this honorable court directed the AG to make the calculation and pay to the petitioner, the department we have written to the AG. Lordship. So he is again challenging that letter, saying that it should be the state who should pay the
So
SCP. Yes.
question is whether those writ petitions should be heard along with this appeal?
Not necessary. If this is allowed, Lordship, those 2 will go.
Your Lordship, the judgment of the single bench is very clear. He is
Very
entitled
confusing,
to,
Lordship.
Your Lordship, the fact is this, in 2000, the petitioner was appointed initially on ad hoc basis. Then in 2002, interview was conducted
What into?
throughout the state. Interview was conducted, Your Lordship. And in 2002, the petitioner was selected. What happened was, all those who appeared the exams, the local candidates for other subjects, they were appointed on regular basis after they passed the interview. For the non-locals like the petitioner, what happened was they were retained after they were selected on contract basis. Then in 2002, the petitioner and the others who were appointed in 2000, they were regularized in service with obviously retrospective effect, only that they will not claim seniority. When it comes to seniority, it will count only from 2001 only. That was the condition that was made. Then in 2008, ACB was granted to the petitioner with effect from 2002 because he had completed 12 years of service under the ACB in 2002.
See, we'll do one thing.
So, Your Lordship-
Since we have just condoned the delay today, we list this matter for remission.
Yes,
some,
Your
some other day.
Yes.
And the question of stay or not will be considered.
Yes, Your Lordship. Yes, Your Lordship.
Wednesday next? Or when?
Lordship, yes. Yes, Lordship, yes.
All right. In view of the order passed today in IAC number 8 of 2023, condoning the delay in filing the writ appeal, list this appeal for admission on next Wednesday, 29th of March.
Much obliged.
For orders, item number 15.
Yes. These are matters which steps have not taken. And who's the applicant here?
The state is the applicant and my learned friend is appearing, Your Lordship.
Any objection
Lordship.
No, Your Lordship.
to the delay?
No, Lordship. No objection.
This IA is in writ appeal.
Yes, Lordship, there is an 88 days delay, Lordship.
All right. Heard Ms. V. Shukre, Learned Counsel, for the applicant. No, you cancel that order. Office note dated 23/2023 indicates that the applicants have not taken steps for service of notice upon the respondent. Stop. However, today, Mr.
Subhamati.
Supungwati,
Walling, yes.
Supungwati, Learned Counsel, appears and submits that he has instructions to appear on behalf of the sole respondent. He further submits that he has no objection if the delay is condoned. Next para, in view of above, notice is deemed to be complete. Next para, by filing this application, the applicants seek condonation of 88 days in filing the connected writ appeal. Against the order dated 10/8/2022, passed by the learned single judge in WPC number 347 of 2021. Stop. Referring to the application, the learned additional advocate general submits that on account of various interdepartmental consultations, the decision to file a writ appeal could not be finalized immediately. Stop. As such, when it was ultimately decided to file an appeal, there occurred a delay of 88 days. To stop, for this reason, the instant application has been filed, and she submits that the delay in filing the writ appeal may be condoned. In view of the fact that it was on account of bona fide reasons. Next para, Mr. Supungwati, Learned Counsel for the sole respondent, has already submitted that he has no objection if the delay is condoned. Stop. Accordingly, upon hearing the learned counsels for the rival parties and upon perusal of the application, we condone the delay in filing the delay of 88 days in filing the connected writ appeal. IA stands disposed of.
Lordship, I pray that similar order may be passed in item number 16, 18, 19, and 20, because we are challenging a common judgment in order.
How many days delay? How many days delay?
88, common judgment.
This is also common judgment.
Yes, common judgment, Your Lordship, whereas the writ petition number is different.
Then you write
Yes.
judgment and order I said in the beginning. Just add one word, common judgment. Common judgment and order, dated so and so. I think the date was
The date is 10/8/2022.
correct? 10/8. Yes, 10/8/2022. Common judgment.
The writ petition number will be different, Lordship.
Give me the next item. Then one more line we can say, that appeal can be listed next Wednesday.
Lordship, in view of this Honorable Division Bench judgment dated 14/9/2022, this petition ought to be dismissed, Your Lordship, because previously the state filed a similar appeal, which was dismissed by this Honorable Court. So, Lordship may pass a similar order in this appeal also.
Writ appeal.
Yes.
It was dismissed.
Yes, I have furnished the judgment, Your Lordship. Yes. The judgment dated was 14/9/2022.
This was passed in what? In which?
This was passed in WA 25 of 2022, whereas
it was against, appeal was against which judgment?
Different judgment, Your Lordship, but the nature of the case, the present bunch of appeal right now before Your Lordship is against the judgment passed by the learned single judge directing the state to pay minimum scale of pay. So in WA 25 also earlier, the learned single judge has directed the state to pay minimum scale of pay, against which we filed a writ appeal, which was dismissed by this honorable court.
In short,
Yes.
you're saying that the appeal is covered by the judgment
Yes,
passed in
yes,
WA
upon covered,
25.
yes, yes, yes.
Brother? They say it's covered by that judgment. This judgment covers
The present appeal, the lordship.
so. No, appeal, where's the appeal? How many IAs are there?
Lordship, there are 5 IA.
No. In item 15,
Yes.
there is one IA which we have just disposed of.
Yes, that
Then
is.
there is a writ appeal. There's another IA.
IA is for the state, lordship. Yes, yes, yes. But during the pendency of this writ appeal, this judgment was passed, lordship. Yes.
Ms. V. Shukre, we have understood what you are saying.
Yes, lordship.
But we'll post it again next Wednesday.
Okay,
And that
lordship.
day you can point it out to the court.
Okay.
Since we are only concerned with the IA today.
Okay,
so
lordship, lordship.
let us not do everything together.
Lordship, lordship.
Then in the main, you write, in view of the order passed today in IAC number 209 of 2022, let the appeal be listed for admission on 29th of March 2023. Then you call the next item.
Lordship, item 17 is not analogous with this writ petition, but they have make it as an analogous, Your Lordship.
Which one?
Oh, no. Item 17.
No, we are concerned with 16 first.
Yes.
Let us go to 16 first.
Okay, Lordship.
16 also 88 days.
Yes, yes, same common judgment order, Lordship.
16 will be similar order. Okay. Only difference would be the WPC will be 344. of 2021. Then main appeal also, same order. Huh? Then 15 and 16 are similar. Then 18.
Yes, 18 will be, read petition will be 345.
Okay, 18 writ petition would be
345.
345. Then, what about 19?
19 and
19
20.
will be
19 and 20 also.
348.
How much?
348.
348 of
2021.
2021. This is also
Then,
similar order.
yes, item number 20 will be, WPC will be 346.
Which one?
Item number 20.
20.
Yes, 346 of 2021.
346 of
21.
21.
Yes.
Then 21 is different.
Yes, a different lordship. Now, item number 17.
Let us see 17.
Yes. Here also, your lordship, there is a delay of 88 days, and the judgment is passed on the same date.
Then what is the difference?
Lordship, because separate petition and separate nature of case.
I see.
Yes.
Not a common judgment.
Not common judgment, your lordship.
Who appears here in this case?
Here, lordship.
Yeah. You have any objection to the delay?
No, Your
No objection. Please write down item 17. Office note dated 23/2023 indicates that the applicants have not taken steps for service of notice upon the respondent. There's only one respondent, is it?
Yes, lordship.
Respondent. Stop. However, today, Miss
Aprio.
given writing Aprio.
Yes. Yes,
Lord.
my lord.
Spelling?
Shall I?
Give in writing to
Okay.
her. Huh? Miss so-and-so submits that she has instructions to appear on behalf of the sole respondent and that she has no objection if the delay is condoned. Next para, by filing this application, the applicants seek condonation of 88 days in filing the connected appeal against the judgment and order dated 10/8/2022 passed by the learned single judge in WPC number 313 of 2021. Stop. Ms. V. Shukre, learned additional advocate general, submits that the delay has occasioned on account of various consultations made between the different departments before deciding to file an appeal. Stop. She submits that since the delay is on account of bona fide reasons, the same may be condoned. Stop. Ms. So-and-so has already submitted that she has no objection to the application for condonation of delay. Stop. Next para. In view of above, and upon hearing the parties and on perusal of the application, we condone the delay of 88 days in filing the connected appeal. IA stands disposed of.
Okay. The lordship, the other IA and appeal may be listed after 3 weeks, your lordship.
Appeal?
Yes, yes,
Okay.
the appeal.
In view of the order passed today in ISC number 213 of 2022, the appeal be listed for admission after 3 weeks.
Lordship, much.
Orders. Item number 21.
My lord, the last occasion notice was issued upon the respondent number 1 and by registered post. We have taken stays, but no one has appeared as of now.
Then who is respondent number 2?
Respondent number 2 is the performer respondent AG, Nagaland. We have served copies to the Standing Council of the AG.
When?
We have served copy
If they have a standing council. you
Yes,
could have-
they have two standing councils.
No, if they have a standing council or one or two, you should have enclosed the acknowledgement receipt here.
The respondent number 2 is just a performer respondent, my lord. But anyway, I can get the endorsement again.
You could have done it in the first place itself. One small piece of paper, acknowledgement, attach it to your IA. All the copy already served. The matter would have ended. Similar with government advocates, isn't it?
Yes, ma'am.
You give them a copy in advance. So notice is served that way because they have a standing council.
Yes, ma'am.
Then one is a private person.
Yes, my lord.
This appeal is filed by
By the
state
Director General of Police.
Who is the respondent number 1?
The respondent number 1 is the
Writ petitioner.
writ petitioner.
What is the direction?
The direction, the husband of the writ petitioner, the respondent number 1, he was declared as deserter. Then after more than 10 years, the petitioner is claiming for pension on the ground that by the time the notices were issued, by the time the husband of the petitioner was declared as deserter, he has already expired. And the Learned Single Court has directed the respondents to pay the pensioner benefits. That is how we agree and we have filed this appeal.
So what is to be done today?
My lord, this notice, we have already served with the notice.
Who was the counsel before the writ court?
Mr. Imti Longcha.
Imti Longchar. He may not be the counsel now, but
Yes. My lord, we can wait for some time. If not, we'll make individual take steps by substituting notice also.
what about the address? Is it correct?
This is the address they have given in the writ petition, my lord.
Let us see what is the address like. Shaki Village, Boka.
Yes.
No house number,
No, house number, nothing.
locality numbers, something like that.
Yes. Maybe we can take this fresh steps by way of substitute notice by publication in the newspaper. This may serve the purpose.
Notice can be issued to this party number 1 through the chairman of the village council of Shaki.
The notice was sent just recently. Recently means 6th of February.
Yes.
So we wait for some time and maybe they can do some tracking. Registry can do some tracking to internet. It was steps was taken by registered post, isn't it?
Yes, ma'am.
Please write down. Office note dated 23/2023 indicates that return service report is still awaited from respondent number 1. And that applicants have not taken steps for service of notice upon the respondent number 2. Mr.
N. Longkumar, my lord.
N. Longkumar, learned counsel for the applicants, submits that a copy of the application has already been furnished to the Standing Council, Accountant General Nagaland, who in fact is a pro forma respondent. He, however, submits that he can serve an extra copy to the Standing Council, if so directed. Stop. Next para, Mr. N. Nonkumar, therefore shall serve a copy of the, one more copy of the application for condonation of delay to the Standing Council, AG Nagaland, and obtain an acknowledgement which should be submitted before the registry. Next para, since notice was sent on 6/2/2023 only, let service report be awaited from the respondent number 1. The registry shall also track the same through internet and put up a note by the next court date. List the matter again after 2 weeks. That's all.